the end of camp or something, yeah.
Okay, we're going to get started this morning. Thank you all for being so flexible in making the move of this meeting to San Francisco. Mimi, why don't we start with roll call?
Okay, Justice Edmond?
Here.
Toby Rothschild?
Here.
Liz Brady?
Here.
Andrew Rita?
Here.
Simon Bowman?
Here.
Tara Bird?
Here.
Judge Wendy Chang?
Here.
Abhijit Sivan?
Here.
Jean Clausen? Johan Drolshagen?
Present on the phone.
Margie Estrada? Lori Gonzalez? Bridget Grammy?
Here.
Andrew Kuchera?
Here.
Joanna Mendoza?
Here.
Kevin Moore?
Here.
Heather Morse?
Here.
Alan Rodriguez?
On the phone.
Dan Rubens?
Here.
Mark Tuff?
Here.
Angelina Valverde? And Joshua Walker? Thank you.
All right, thank you all so much for being here or being on the phone. We now are going to call for public comment. I received a note that we have with us Christopher Sanchez with the Coalition on Human Immigration Rights. Why don't you take a seat at the table, turn on the microphone, and the floor is yours. Welcome.
Hello. Thank you, Madam Chair. Good morning. Good morning, members of the task force. My name is Christopher Sanchez with CHIRLA, the Coalition for Humane Immigrant Rights, California's largest immigrant rights organization with a membership based throughout the state of California, directly representing immigrant families. In addition to the known services that we provide to the community, CHIRLA provides immigration legal services that include deportation defense and affirmative relief. As an organization that strongly advocates for consumer protections on products and services that our communities rely on, CHIRLA strongly opposes most of the recommendations the task force is proposing. Unfortunately, immigration policy has changed drastically over the past several years, and it is our firm belief that things will not get better regardless of what happens in November. The direction that immigration applications continue to be denied for many reasons that agents that are USCIS agents are analyzing based on direction given under this administration, which has only empowered them for once the administration is to leave, that they would be able to continue these tactics. We would ask the task force to delay sending the recommendations to the trustees to have further input from community members that are directly impacted on such services or that advocate for these communities. Unfortunately, our clients and our communities are not able to have pilot programs or seek programs that are experiments. Our communities have to get it right the first time. A negative adjudication for a client based on going to seek a service that is not properly trained or that does not have proper knowledge of immigration policy could lead to deportation, removal, and so forth, and denial of benefits. It is our responsibility and this body's responsibility to get it right the first time. Thank you for your time, and we look forward to engaging the task force and board of trustees with these recommendations and on this topic.
Thank you very much. Any questions for Mr. Sanchez? Thank you, sir. Is there any other public comment? Hearing none.
Yes.
Oh, yes. I'm sorry?
Yes, I'm
I'd like to participate in the public comment.
Okay, could you identify yourself, please?
My name's Chris Steffen. I'm a member of the bar, and I'm the principal of a small firm called the Limited Scope Law Group.
Okay, you can proceed.
And I just recommended. Thank you. So, without going into much detail about how the practice works, because the title kind of explains itself, we specialize in limited representation. Just working in that space has sort of made us come into contact with a whole lot of what I refer to as non-attorney legal businesses, or NLBs for short. And these include lots of, registration hats, legal document assistance, unlawful detainer assistance, credit service organizations, the list can go on. I know the task force's sort of claims that looking at this is what sort of wiggle room there may be to loosen up some of the regulations for some of these NLBs to sort of get around some of the logistical systemic barriers that, frustrates the process of getting legal service from their end. And we see sort of the ramifications from that because almost all of our clients start with an NLB, most often a legal document assistant. And we're sort of unraveling what will happen sometimes by virtue of what the limitations on, say, legal document assistants are. As it stands right now, legal document assistants aren't allowed to select forms, judicial counsel forms, and it sort of adds steps to the process for their customers that oftentimes takes the form of filing a request for order, say, in family law. It puts the court sort of on a detour of what the case may really need. A lot of that can very easily be eliminated simply by sort of giving a little bit more rope to a properly registered LDA, provided that there's some sort of mechanism in place to limit or sort of enforce non-registered, properly compliant LDAs, because there's a lot of them out there as well. I would also like to point out that some of the same systemic sort of logistical challenges also come into play for limited representation. In terms of looking at the space, looking at sort of how can the delivery of legal services be streamlined to better address the justice gap, there's also a lot of wiggle room in that space and sort of carve-outs for when you are doing limited representation that I also think should be sort of brought into consideration, at least when we're talking about, action in state court. Thank you very much.
Thank you. Any other public comment? Randy?
In the room at the back table, we did receive an email comment from Brian Pangerly. He did call and provide oral comments. We asked him to submit it in writing. So please, if you haven't already drafted, take a look at his public comment. He has some recommendations at the end. And it's available to any member of the public if you'd like to receive it as well.
And we received a letter from Legal Aid Foundation of Los Angeles. Has that been circulated to everybody?
That is available as well. And I think when we get the staff report, maybe Toby and Bridget can talk about their outreach forum, and I think that's where that letter came from.
Okay, terrific. Then hearing no other questions or comments. Yes?
Excuse me, can you hear me?
Yes.
This is Brian Pangerly, and I greatly appreciate your time and patience and the notification of making availability the written comment that I provided. And my practice has been mainly in the field of intellectual property law. I've counseled in Native American communities, pro bono, small communities during the mortgage crisis, as well as for small business administration. And one of the important points that I would like to draw out is that there has been the use of the term innovation as a code word for what some entities want to deregulate. And so I'd like to point out is Professor Hatfield from Canada her position paper for Cato Institute, and she's an advisor with LegalZoom. If you look back in 2008, she was saying that there needs to be deregulation in the corporate legal market. And she distinguished that there's a difference between the corporate legal market of very sophisticated actors and the other function of law, which has to do with individual rights, dignity, autonomy, etc. She said it shouldn't go that far. And what I'm hearing from the conversations and documents with the task force is that there are some entities that are really pushing for moving that boundary, and basically contrary to what Professor Hadfield had written in 2008, they now want to open up this whole code word of innovation, which what they really mean is deregulation. And they really want to advance that agenda. And I would say just let's take a look at what happened to deregulation of hospitals. Have healthcare costs gone down? No. Have outcomes improved per dollar? No. It's funny that we have people from Canada where we are now looking to implement their type of healthcare system, but they're looking here to come into the United States and tell us that we need to deregulate our legal market. Maybe for corporate, okay, but for individuals, I think we're going to have some serious issues, and I think the healthcare industry stands as an example. And I'll just end it there. Thank you again for your time.
Thank you, Mr. Peggley. Okay, any further comment? All right, the next item on the agenda is the chair's report. I think you all have received a copy of the latest Justice Gap report, and in particular the executive report. It is something that we would encourage everybody, if you haven't had a chance to read through it yet, to do so. As we have conversations following our report to the Board of Trustees, I think it's important that you're aware of what it says in terms of the needs of Californians at this point in time. And so that's just an informational item that has been provided to all of you. The only other thing I have on my agenda is basically to give you a roadmap of where we're going to go today. And how we're going to try to get through all this material. We definitely are on the home stretch. And so this is the order that we are going to go in. If you want to make a note for yourself, or if you just want to be surprised, you don't have to bother writing it down. But this is what we're going to do. We're going to take it in this order. Item B1, which is the Rule 5.4 revision. It has been slightly revised since we discussed it before. And so as to some of these items, we probably will take a two-part vote. A first vote on the actual substance of the matter, and then a second vote with this body authorizing somebody to work with staff between now and the time that our report goes out to make sure that it's final and in perfect tip-top form. So B1 will be the first item. B8 will be the second item. That's Rule 1.1. We've already voted out the substance of that, and basically we'll just be looking for a vote to authorize somebody to work with staff to finalize it. We're going to go from B1 to B8 to B4. That's the UPL exception, the triple LT or whatever, paraprofessional, whatever we want to call it. Then to B3, which is the sandbox proposal. Then to B2, which is Rule 5.4, Statement of Intent regarding further study of 5.4. Then to B5, which is ABA Model Rule 5.7. Then to B6, which is the Certified Lawyer Referral Service, encouraging further study of that rule. B7, Advertising and Solicitation Rules. And finally, C1, which is just talking about how we go forward and present this to the Board of Trustees. So, one more time quickly, if you want to write it down, B1, B8, B4, B3. Did you hear him say bingo?
You sunk my battleship.
B2, B5, B6, B7, and C1. Gotta have a sense of humor. Okay. That's all I have for the chair's report. Randy, I'm going to turn to you for the staff report.
I only have 2 minutes for the staff report. Actually, one of them is the NORC survey, and I see Leah is with us today. The survey group, NORC, did have to back up the delivery date for the initial sort of raw report, and so we don't have that. We were expecting today, but it'll probably be more so around the 3rd. It will definitely be ready by the time of the board presentation on the 12th. Some initial, called tentative inferences or findings was provided to us over the weekend, and we have a copy of their correspondence at the back of the room. And Leah, if you just wanted to say a few words about that. They are rather interesting.
Yeah, they are. Looking at the summary that NORC provided to us, they didn't include the statistics that they gave over the phone, but the takeaway from their survey, and recall this is a random survey of folks in California. They did sample based on income levels, English as a first language, geographic location. So we got a very good representation of the state population. And they found that lack of access to the internet is not a major barrier here in California. And in fact, we have higher access rates even at the lowest income bands than you find nationwide. And that is access to the internet on your phone, but also access to a computer, which provides more functionality than just a phone. So they thought that was a very interesting finding. They don't see that we have an access issue in that way. But what they do say, they also found that a majority of Californians, those that they surveyed, have in fact looked for legal information online already. However, they said that the huge barrier is about privacy, and that people across all income levels are very concerned about privacy and data security, very distrustful of that, on those issues. And then I thought this was really interesting. Californians place a higher priority on lawyers owning a law firm they might consider using than they do on lawyers owning a legal advice website they might decide to use. They make a distinction between, if I'm going to go in person physically to see a lawyer at a law firm, I care more if a lawyer owns that firm than I do via conference online. So I think it was really interesting, key takeaways. They asked for some additional time to complete the final report, but it will be available to package up with the Adams report to go to the board in March.
Terrific.
Sorry, guys. I just wanted to jump in. It's Lori Gonzalez.
Hi, Lori. Welcome. Ray, do you have anything further?
So we do also have latest development from the ABA. On February 17th, the ABA House of Delegates approved a resolution encouraging U.S. jurisdictions to consider innovative approaches for responding to the access to justice crisis. Resolution 115 was supported by several ABA groups, including the ABA Center on Professional Responsibility and the ABA Center for Innovation. The final language, it's the ABA Standing Committee on Ethics and Professional Responsibility, not the Center. And the final language adopted included an amendment clarifying that the ABA's action should not be construed as altering any ABA model rule, including model rule 5.4. Of course, that restricts fee sharing with non-lawyers. Almost goes without saying, the work ADLS really aligns with this resolution because we are absolutely encouraging studying innovative solutions. The only other item for the staff report is, if I could, pitch it to Toby and Bridget to report on their latest informal forums that they've been having between meetings.
So last week we had one of these roundtable forums for services lawyers live in Oakland and by phone from San Diego, LA, and some other places. And we went through the key recommendations and got some feedback on both the personal, figure out my notes. On any of the things that we're talking about, one of their concerns was who the regulator is, whether it's on the sandbox or on the individual non-lawyer activity, paraprofessional activity. They think that the state bar has not been effective and is not an effective regulator in these kind of situations, pointing to things like Legal Match and LegalZoom and all that haven't been regulated, and that there needs to be a more effective regulation. On the board that's going to oversee the AI stuff, the sandbox, they listed some other people that weren't on that weren't necessarily on the list. They talked about a consumer representative, constituent, a successful, modest means legal provider, a consumer protection advocate, somebody who's an expert in AI, and that dealing with harm during the sandbox, they're clear there needs to be a good dispute resolution and the question of personal liability, and not just taking away a license, but personal liability for any harm. Again, trust is the big issue. Who appoints the board? Who oversees it? These are volunteers, so their time is not full-time on this, so they're somebody who, particularly whoever then is the staff that's providing the information to them, needs to be trustworthy as well. They talked about including, since most of the things we're talking about are limited scope kinds of things, that there ought to be the same kind of restriction on limited scope as there is in Rule 1.2 in terms of informed consent, knowledgeable about what that means and what the risks are, and getting informed consent. Marketing ought to be limited the same way it is for lawyers, that there ought to be not just the dark whatever, but also truthful and fair and the other things that limit lawyer advertising and marketing. Let's see, on competence, enough to help. It needs to be enough competence to help. Let's see, again, ethical marketing, informed consent. And some discussion about how to work with interpreters. If have to communicate with someone, there ought to be, because interpreters become a part of that process, how do you work? It needs to be training. Part of the training is how do you work with interpreters, and how do you deal with machine translations and the like. And I think that's what led to the letter that you saw from the Relay Foundation of LA, was response to that, furtherance on that discussion. Anything else, Bridget?
No, I think you summarized it really well. I would just say overall it was a positive meeting, actually. I mean, I think they were really engaged and had a lot of very good questions and comments. A lot of them I think we've already addressed in our memos. The one other comment that someone made when we were talking about paraprofessionals was asking whether we've really assessed the market, and whether someone was commenting they have trouble recruiting attorneys as it is. Are there even going to be people that are going to want to fill these slots? And so I think we've heard from Lori and maybe some other people making that question. So perhaps we can make that more clear in the memo that you did, Joyce, which, by the way, I thought was great. And the only other thing I was going to add, we can put these, but when we were talking about recommending people that would be part of the regulator, someone who has knowledge of bias and how to read algorithms was one of the things that they had recommended, which I do think is really important. And I think, just that was the big thing I do think is this comment, we don't trust the regulator. So I think we've made it pretty clear in our memos, but maybe we could make it more clear in our final report how important building that trust is going to be to consumer protection going forward.
Just one last comment, and that is, as Bridget said, how positive most of the comments were. They were really very appreciative. They thought that the sandbox was a great idea. These people received these memos I sent them out about 5 o'clock the night before, whatever the current draft was as of Tuesday night. for our meeting on Wednesday, and they had read them all. And they were up to date and understood what we were talking about. The meeting was at 2 o'clock in the afternoon on Wednesday. And they had read them and had specific comments about them and really thought they were very good.
Oh, sorry, I do think one other thing. I think I've heard some comments both this morning on the phone and looking at some things, and also just in the context of these roundtables about a fear of deregulation. And I think that is something else that maybe we should make explicitly clear in our final report, that what we are proposing is not deregulation. It's really not. And so I think it's really important that we correct that misperception. And even with respect to some of the comments we heard this morning about allowing, paraprofessionals or non-lawyers to do things and how that might harm the public, I think we need to just make it clear that this is not a Notario situation. This is something really different that we're proposing. And so I don't know if that would be in an executive summary or how we can communicate that clearly, but I do see how catchphrases catch fire, and I really would be very disappointed if that's what the outcome is, what people think about what we're proposing.
Okay.
Bridget, if I could just ask you a quick question. You said something about they, I guess maybe the participants, were concerned whether there would be anyone to fill these positions. What was that about? I didn't quite follow that.
Sorry, about the paraprofessionals. So they were talking about if we were going to have an additional licensing category, and are we envisioning people that are going to hang out their shingle or just operate independently as paraprofessionals? Is there a market for that? Are there people that even are interested in doing that? And have we assessed that market is the question. Because what their comment was, we're having a hard time finding lawyers to fill these positions that we're offering in these legal services market, and is there even anyone out there that wants to do this as a paralegal before you go through all of this regulation reform? Does that make sense?
Yeah. Is that tied to how much they can earn?
Maybe. They didn't expressly say that. I don't think. Toby, do you know? Maybe that is part of it. Was the salary part of the reason that they can't recruit people to work in these legal
part of it's that. Part of it's just in the current market. It's a very strange market for legal services, particularly in the Los Angeles area, but I think throughout the urban areas, at least in the state, where there's all sorts of money being poured into specific things like homelessness and immigration, and programs are cannibalizing each other because there's just not enough lawyers that want to work in this field. It's been hard to fill a lot of positions.
And
The
retain
particular
them.
person I was talking to is from one of the smaller programs that probably can't compete on salaries with, LAFA and PetSetic and Public Counsel and the other larger programs.
Other questions?
For Bridget or Toby?
Well, let me say once again, thank you to both of you. This is so important because, you really are our ambassadors. I recall a day that I had somebody in the legal services arena come and sit in my office and say, just a heads up, we're not happy with the way this is going. And it's really important that you get the word out about what really is going on here and what the intention is. And I appreciate your input in terms of highlighting in the executive summary or somehow getting the real truth out about what this is.
I should point out, one of the people who was at this roundtable was one of the people who was most vocally opposed at the very first legal services meeting we had when the process first started.
Great. Well, thank you both. Yes, Joshua.
Just a quick question, and I don't know if there's a mic nearby. Thank you. You can keep. No, I'm kidding. What can we learn about short-circuiting the Notario, propaganda? I don't want to say call it propaganda, but there is that real fear of it's not correct or wildly. What can we learn in general from that?
To me, and I'm interested to hear what other people think about it, I think this is one of the hardest problems that we have to deal with because it's legitimate. People have been really hurt by this.
Yeah.
And I don't know, to me, I think communicating that this is the opposite of the program that is going on right now, which is largely unregulated. It is just people are out there and they're registering somewhere and they're not really controlled. And so I think what we're proposing would be a very different level of professional that is regulated by a board that has a license, has to go through things. There are consequences for poor behavior that, in making it clear that this is actually the opposite of what's happening right now as far as regulation. Maybe, but I mean, people who have been hurt by this, and I don't know. I guess the other thing would be, I think it would be important. I can't remember who is recommended to be on this working group for paraprofessionals, but if we do have someone from the immigration community, do you know, Andy? Or you don't know, so anyway, maybe someone from the immigration law community to help to advise, I think would be really helpful in the paraprofessional category.
One of the things that came up was there's so many people that need to have a place on this that what might be useful is an advisory committee that would review what's going on. It wouldn't necessarily have to be voting members of the panel of the regulator, but would be advisors to the panel that could cover a whole range of options of people that we need that need to have input directly into the process.
Yeah, that was actually something that we put into the sandbox proposal, but there's no reason that it couldn't go also into the paraprofessional side of things. But this is just a model that they use in the UK, which is a consumer advisory panel that they have that exists separate from the, it's part of the Legal Services Board. They advise the Legal Services Board, but it's a, do you know what I'm talking about?
They use it in a bunch of different statutory vehicles.
I think it's really important, and I think that would really help. So perhaps, and maybe our final recommendation, it wouldn't just be for I was focusing on the sandbox when I wrote that, but perhaps this is something that we can add to the paraprofessionals as well today.
The other thing we talked about at this roundtable was that what's really needed is for the regulator, whoever it is, to do effective marketing to the community to say, be sure to go to a certified, authorized place and don't go to one of those.
And I think that should go, right, that you have to allocate, you need budget for that, and so we should actually make that functional.
Yeah, there needs to be marketing from the regulator, not just from the participants, but from the regulator saying, be aware that we're out here and we can, assure to the extent anybody can, competence, which you don't get otherwise.
You could probably do that pretty efficiently, internet stands, if you will. Yeah. Thank you.
Any further questions? Okay, I think we have one action item, which is to approve the action summary from the February 4, 2020 meeting. If we could have a motion, please.
So moved.
Okay, so
Second.
moved and seconded. Yumi?
Andrew Rita,
Yes.
Simon Boney,
Yes.
Sarah Bird,
Yes.
Rich Wendy Chang,
Yes.
Abhijit Shaban,
Yes.
Jean Clausen, Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby,
Yes.
Cody Rothschild, Ellen Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Huff,
Abstain.
Angelina Valverde, and Joshua Walker.
Abstain.
Thank you.
Okay, thank you very much. And that takes us to item B1 on the agenda. And I have a note that Kevin and Toby are going to take the lead on this.
You want to start, Kevin, or shall I?
I can do. This follows up on our discussion from the February 4th meeting when Toby raised an issue that as drafted, A5 might have precluded the sharing of legal fees with some organizations, portable legal fees.
Have you got your mic on?
Yes,
Thank you.
I'll get closer to it. It was a concern that there might be a conflict with a comment that we have included in the rule 5.4 regarding the sharing of court-awarded legal fees, that the types of organizations are broader. There's a broader scope of the kinds of organizations, nonprofit organizations with which you can share legal fees when they are court-awarded. So the A5, the drafting team revised A5, and it's a two-tiered process if you follow along with me, that where it's a court-awarded fee, that's Romanet number 1, that's A5 Romanet number 1, then you can share it with a nonprofit organization and there's no limitation on it. The theory being that under those circumstances, although there is a concern there can be abuse with sharing legal fees, generally with nonprofits where like lawyers form their own nonprofit organization and share fees, that's not going to happen when it's a court-awarded fee because you have the court to supervise. The second part, the Romanet number 2, is where it is as a result of a settlement. Under those circumstances, it would be limited to 501c3 organizations under the Internal Revenue Code. We took the lead from the District of Columbia rule that had reviewed the situation and decided they should expand the sharing of legal fees just as this task force decided, but that they had a concern with the potential for abuse that they had experienced in the past. So essentially, we keep the law as it is, as far as court-awarded fees are, and have a broader scope of legal nonprofit organizations. But as far as the settlement fees as the result of a settlement, then it's going to be limited to the 501c3. And that was the change that was made.
Toby, you want to add anything?
No, I think that says it.
Any discussion? Mark?
I just have a couple of comments. You also say in your report that you've added the word facilitates to the operation of this change, and that is going to apply to both Romanet 1 and Romanet 2?
Yes.
Yeah, that's great. That was in the previous drafts of that. It's not new in this draft.
That had inadvertently been dropped from an intermediate draft. The word facilitates.
You have a footnote in your report that sort of tells us what you mean by facilitate. I'm not sure that that will be carried over to the people who aren't here. I'm wondering if it deserves some explanation or comment, because I don't know what it means. So you might want to explain that. More than just in a comment in this report. My other comment is there is a paragraph on page 2 that in my copy anyway still has some language about inserting some language. And it looks to me as if it pertains to a topic or agenda item B2. Am I talking about that? This is the.
That's correct.
And so, what's the status of that?
That's next on the agenda.
I know, but if we vote on B1, are we voting on that paragraph?
No, separate item.
No, after we finish this, whatever we come up with when we discuss B2 will get fit in.
It's coming.
Well, I understand that, but what about this paragraph that's in the report?
You're not voting on this.
We're not voting on it.
Not for, let's see, 3 or 4 items.
Okay. All right, those are my questions.
Okay, go back to facilitates. What's the response from Kevin and Toby? Do we need any explanation, or is facilitates self-explanatory in your views?
I don't think it's self-explanatory. I think you'd have to read what your explanation is in this report. It's not going to be clear to those who use this rule in the field. If you adopt the rule the way it is written, I think it's going to be very confusing as to what you mean by it. So it deserves a comment. If you want the word, it should have a comment as to what you mean by facilitate.
Can I win?
Joanne?
The recommendation is to send it out for a public comment period. It seems to me we could do that during the public comment period and fix any nits at that point that we want to fix. We're going to have to make a decision today, and there's no time for us to draft a comment and approve it, given everything else we have to do. I think we just leave it to the public comment period, and I know, Mark, you are going to provide that wonderful public comment.
I have no idea.
I have confidence that you will. That would be my recommendation.
Yeah, then I have another question. Is this a recommendation that a rule such as this go up for public comment, as opposed to that this is the rule that the Supreme Court should adopt?
I think the recommendation is that the board treat this like a recommendation from Rule Revision Commission. It comes to the board sends it out for public comment. And then,
So we're recommending that the Supreme Court actually approve this rule?
No. All we're doing is recommending to the Board of Trustees that it send this out for public comment.
prior to submission to the Supreme Court.
Yes, Andrew.
I just wanted to vote that I think the word facilitates is self-explanatory enough to leave it in there without comment.
Okay. Do we have a motion?
Move to approve the draft rule, the proposal.
And that's a second, Daniel. Okay. So it's been moved and seconded as is. Okay? And now we're talking about the black letter. This rule, later we'll talk about this whole issue of the, as Mark points out, but we're going to plug into the language of the report. Any further discussion about Rule 5.4? Hearing none, Mimi.
Okay, the motion is to approve the recommendation as drafted. Andrew Ruda?
Yes.
Simon Bowman?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang?
Yes.
Abhijit Sivan?
Abstain.
Team Clausen? Johan Drolshagen?
Abstain.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Granby?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morris?
Yes.
Joyce Raby?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Dan Rubens?
Yes.
Mark Tuff?
Yes.
Angelina Valverde? And Joshua Walker?
Yes.
Thank you.
All right. Thank you very much. And Randy, do we need a separate vote on the issue of authorizing Kevin and leadership to work with the staff to finalize the report?
I would like that for the record, but how about we hold that in abeyance until we resolve the issue that Mark has raised about the plug-in of the further study language. So why don't we get to that and circle back and we'll do the reported recommendation authorization.
Okay, then we're going to move on to B8. This is our competence rule 1.1. Kevin and Randy?
So I'll jump in. This rule was previously approved. It has not changed at all. All we'd like is a vote to authorize, and if I could script Professor Moore to be sort of the guide to staff between now and when the board materials post. Staff will be working feverishly to put together a final report and recommendation, including a cover agenda item that will convey this. And to be able to have a member of the task force authorized to work with leadership and staff to pull this all together quickly would be of great assistance. But we wouldn't want to do it without something in the record saying that is the will of this body. But
Okay, so then I would entertain a motion that would authorize Kevin and leadership to work with staff to finalize the report.
So moved.
Second?
All right, it's been moved and seconded. Any discussion? Hearing none. Mimi?
Right. The motion is to authorize Kevin and staff to finalize this report on Rule 1.1.
Kevin and leadership to work with
Leadership.
staff. No problem.
All right, Andrew Ruda? Simon Bowman?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang?
Yes.
Abhijit Javan,
Yes.
Gene Clausen, Johan Droshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore.
I feel like I have a conflict. Do I abstain? No, I'll say yes.
Okay, Heather Morris,
Yes.
Joyce Raby,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
All right. Now we're moving to item B4, which is our paraprofessional UPL exception. Joyce, I'm going to turn it over to you.
Okay, that's fine. We did another round of comments. I'm going to summarize briefly the things that we did. We added information regarding startup costs, and we added a section that referred to the potential need for fingerprinting as part of the background check. We clarified in the document and consistently used the term paraprofessional rather than LLT. And Kevin, thank you very much for some significant editing for clarity, just generally through the document, making sure that the language is clean and consistent. There were two comments, one referring to fee sharing and the safekeeping of funds that we got from Mark. And I believe, Randy, I'm going to defer to you if you would be so kind as to, you made those, you modified some of the language, I think, to incorporate that comment, those two comments. Yes? Because that was not work that I did. Is there any, do you have anything you'd like to say about those two comments?
We are trying to have a little bit of a template for the reports and recommendations that include sections on the charter, how it responds to the charter, and also the box score with all of those public comments that came in some of the major themes. So that's something that we're going to try to incorporate in each section of the final report for each item. And so to the extent we had a memo that was suitable for that, we went ahead and added that. In addition, there is, for many of the others, a short statement of the recommendation. This one included, and what I want to say about that is oftentimes with stakeholders or even with the board, certainly with the media, you don't have the luxury, like the group that Toby and Bridget spoke to, of someone who is willing or able to read the whole thing. And so having a short statement of the recommendation that everybody agrees with will be very helpful. I wouldn't want to get into a situation where that short statement is used in a press release or for outreach, and then someone here thinks, well, it didn't capture exactly what I voted for. So please pay close attention when we have it to the short statement of the recommendation, because that's what we like everybody to use when you don't have the opportunity to give any sort of fuller treatment of these important recommendations.
The two, I want to make note that there have been two already in the meeting today, sort of what I would consider to be friendly amendments. One, some market research around whether there's going to be sufficient individuals who are going to want to take this path before we go down the path. Looking at the comparison table that staff put together that talked about Utah, Arizona, and Oregon, we may want to do some, and I am volunteering Randy to do some of that research, perhaps to incorporate a comment or some additional, I don't think it's a key consideration, but I think maybe sort of something that provides additional context around where we think they may find these individuals and how to market to them, or identify if the market exists. And the second one was the use of an advisory panel that would exist separately from the regulatory body that would allow for a more broad range of participants in terms of oversight of the implementation of this program. And that is also something that I am willing to work with Randy or staff to incorporate into this document. Those feel like rather friendly, non-controversial. I don't know that we need to. We had previously voted to approve this in concept. I just make note that those are probably two additions that need to be addressed somehow, and that I'm willing to do that if that's
acceptable.
This is a perfect example of why we're authorizing folks to work with staff to line this all up. And
Yeah.
we'll definitely work together and develop.
So unless there's any additional discussion, I don't think any of the modifications or changes that we made were significantly substantive. I don't know if that's the right, oh, Bridget, please.
This actually is just in light of Randy's comment about the short statement. I just wonder if there's a way to very broadly categorize what the key principles are in the short statement. Even if it's just, including, consumer outreach, continuing education, or, education requirements, that, just very high level, but in a way that because I think you're right, I think people often just read the short statement and that's it. So if there's a way that we can capture at a very high level what our recommendations are in that statement, and I think staff could do that. I mean, I think you could just take the headings even that you have below and kind of incorporate them in. That would be sufficient in my view.
And that again feels like a very friendly amendment that I'm willing to entertain.
Go ahead, Joe. I was just going to suggest that in the number 2, consumer understanding and outreach, there ought to be a reference to the regulator doing outreach to the public, which I thought was what that meant when I first saw it, but it needs to, I think it needs to say that's part of their function, is to make sure that the public's aware that these people exist.
Okay. I don't think.
I think Bridget's point is a good one, that we highlight the consumer protection aspect of these principles right there, and somehow capture it in the short statement. Any further comments about this? So I see taking 2 separate votes here. One, I would entertain a motion to approve in principle this passing on of the recommendations to the Board of Trustees and the State Bar Paraprofessional Working Group. And then a separate vote authorizing leadership to work with staff to finalize the report. So why don't we start with motion number 1?
So moved.
Okay.
That's what you said.
It's been moved and seconded.
Sorry,
I know.
I don't know what the motion is. Sorry, I was.
We're approving this.
Approving the
Okay.
recommendation.
Approving the recommendation. All right.
Motion is to approve this recommendation.
And it's been moved and seconded.
Who seconded?
Dan.
Thank you.
Okay, Andrew Rita,
Yes.
Simon Bomey,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang,
Yes.
Abhijit Shaban,
Yes.
Jean Clausen, Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes.
Joyce Raby, Toby Rothschild,
Yes.
Alan Rodriguez, Alan,
Oh, sorry, I didn't hear that. Yes.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
And now I would entertain a motion that would authorize leadership, AKA Joyce, to work with staff to finalize the report.
So moved.
Second.
It's been moved and seconded.
All right. Motion is to authorize Joyce and staff to work on this recommendation.
I think we're just calling out leadership.
Leadership, okay. Andrew Rita,
Yes.
Simon Bomey,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang,
Yes.
Abhijit Shaban,
Yes.
Johan Drolshagen. Johan, you there?
Yes.
Are you voting yes?
Sorry, yes, I'm here, and yes. Sorry, there's a little bit of a delay.
Okay, Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes.
Joyce Raby,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, and Josh Walker.
Yes.
Thank you.
This is very good, folks. I made my plane reservations too late tonight. Okay, we're moving on to item B3, which is the sandbox proposal. I'm going to turn it over to Joanne and Bridget.
So hopefully you've all had a chance to read it. We've fleshed a lot of things out, but I think it looks pretty freaking awesome. The only thing is on the recommendation, I think the way we've worded it, it leaves it kind of sounding like we want more study to determine what the sandbox is going to look like, and I think we need to change the language a little bit to state that we want the appointment of a working group to develop and implement a regulatory sandbox, so that we have a more action word there.
Okay.
We took everything from the last meeting, and hopefully we worked everyone's comments in and added some more good stuff.
Discussion. Yes.
Really excellent job on this. The only thing that I would suggest is I noticed the balancing test of the anticipated access to legal services benefits are likely to outweigh the potential risks of harm. I suggest adding the word substantially outweigh, just because you don't want to make it sound like, oh, okay, this is going to hurt 50 people, but it will benefit 51, so therefore it's good, and it will be approved. So just a suggestion.
Can you remind us where that is?
Oh,
It's part of the executive summary.
and it's repeated later on at some point. Two
to it.
spots, yeah. That
Right
way.
here, here's another one on page 5.
Expansion in that way everywhere.
I thought you were going to recommend the working group be called Paddles too. Which I cannot
Okay,
get out of my
we'll
head.
throw in that as well.
You also mean the first the end of the first paragraph of the executive summary at the last
Right.
sentence too?
Yes.
Just want to make sure. I don't want to just blow.
Got it.
So it's 4 instances. Okay.
Okay, it's a friendly amendment. Any further discussion about the sandbox recommendation? Randy?
I think you all noticed that what we incorporated into the sandbox memo was Dan's and his team's good work on the accessibility issues, particularly in light of what was the tentative findings from the survey, given the California consumers' views about the internet, concerns about privacy. I think building this into the sandbox is very appropriate when we're talking about the tech-driven applicants to the sandbox. So I'm glad to see that the survey supports the direction we're going.
Any further discussion about this recommendation? All right, so I would entertain a motion that we approve this recommendation and a separate motion to authorize Joanna and Bridget and leadership to work with staff to finalize the report.
The second motion is only going to be able to be Bridget because I'm fleeing the country as soon as we're done here.
Which is fine.
Where are you going?
I'm spending a few months in Spain and Portugal.
Oh.
There's technology for that.
No internet.
Give me a motion to bring me some.
So the second one is unfortunately for Bridget, it's going to be her.
Okay, Bridget, it is. Is there a motion to approve the recommendation?
So moved. Second.
All right, it's been moved and seconded. Any further discussion? Okay, Mimi.
All right. The motion is to approve the recommendation. Andrew Ruda?
Yes.
Simon Bowman?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang?
Yes.
Abhijit Shaban?
Yes.
Jean Clausen? Johan Drolshagen?
Abstain.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morris?
Yes.
Joyce Brady?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Dan Rubens?
Yes.
Mark Tuck?
Abstain.
Angelina Valverde? Joshua Walker?
Yes.
Thank you.
Thank you very much, and then I would entertain a motion that we authorize Bridget and leadership to work with staff to finalize the report.
So moved.
It's been moved.
Seconded. Yeah.
Moved and seconded.
Who seconded? Sorry.
Heather.
Thank you. All right.
Any discussion? All right.
Motion is to authorize Bridget and leadership to finalize the report. Andrew Weir.
Yes.
Simon Boney.
Yes.
Sarah Bird.
Yes.
Judge Wendy Chang.
Yes.
Abhijit Chavan. Abhijit.
Yes.
Gene Clausen, Johan Drosselman,
Abstain.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy. Yes. Andrew Kuchera,
Yes.
Joanna Mendoza, Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Brady,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
Terrific. Mark, guess what we're doing next? B2 is Rule 5.4 and the Statement of Intent Supporting Further Study. Now, I've got down, this is a report out from Joanna and Johan.
I wasn't involved in this. I could take it, but I don't think I'd be the best person for that.
Yeah, Lori. Lori? Lori or Johan?
Oh, our favorite. Right.
Randy, why don't you address this? Just for fun.
It's a little hard to hear. This is Lori, so I'm sorry about that.
Not a problem.
So the materials, B2, you'll find 3 paragraphs that were developed by staff and sent out to the team, trying to coalesce the somewhat divergent viewpoints expressed around the table at the last meeting with regards to the clarification of the task force's intent, that by virtue of adopting and recommending for public comment a version of amended Rule 5.4 that includes a modest exception to expand fee sharing with nonprofits, that should not be taken and not misread as a recommendation that the task force believes that 5.4 is one and done, that there should be no further study. And so this particular statement is intended to clarify that and say, we absolutely believe that there should be further study. Some of it, big ticket items like non-lawyer ownership, might be informed by the data from the sandbox. Other aspects might happen while the sandbox is still in operation, or maybe even before it gets going. If a non-lawyer paraprofessional proposal is adopted, and lawyers might need to share fees or collaborate with them, then you might have to go back to 5.4 in order to make the most out of that paraprofessional proposal. And so this statement was originally one long paragraph, but thanks to the input from, I think it was mainly Lori and others, it's been broken up into 3 paragraphs. And for the record, we included the comment from Johan. He was first out of the box when the comment draft statement went out, saying that he doesn't believe that the sandbox should be referenced here. And it's really not a statement, clarification statement, where we are trying to say that you have to wait till the sandbox is over. I didn't write it that way. That's what really wasn't what I intended. But I can see where some might say that as long as you reference the sandbox, that gives any person who's resistant to change a crutch to lean on to say, don't do anything until you see the sandbox data. And so I certainly understand Johan's point, but he's on the phone, so he can speak to himself. Lori also reviewed it, and so if she has any other points she wants to add as well. And I think, Joanna, I might have mentioned you as probably one of the presenters on this, because you and Bridget sort of espouse the contrary view that for something like non-lawyer ownership, passive investment, for-profit fee sharing, that sandbox data would be critical. But that's where this came from.
Okay, Johan, you want to add anything?
No, actually, I'll say that I'm pretty pleased as a whole, just because I think the concept needs to move forward, knowing that it's a broad issue, and the only thing that I asked, which is why I responded so quickly when this went out, is that it just not be pigeonholed into the sandbox, which could potentially delay things up to 5 years in terms of seeking the data. And I think this is something that it's gotten so much attention lately without getting mired into the details, but with Resolution 115, plus the statement that came out from the Chief Justices, you know, this is the central issue, and it needs to be searched into at a much greater length by people that have more certain amount of time and a singular focus. So I'm actually pleased with these 3 paragraphs.
Okay, terrific. Any further discussion on these 3 paragraphs?
This is Lori. I just wanted to throw out for this task force and then moving forward, and this doesn't need to go in, the paragraphs are great as they're written, but just a note from conversations I had over the past week with one of the ABA Center for Innovation individuals. Johan referenced there was a resolution by the ABA passed, and within those were resolutions meant to spur innovation and meant to guide states. And I found it interesting in my discussions that the ABA is really looking for the state to begin this experimentation. I know California is on the cutting edge, but a lot of states tend to follow the ABA's lead, and I think it's important that any future task force from California know that the ABA is really looking for the states to take that lead, especially when it comes to Rule 5.4, which I think may have been why there was no movement from the ABA on 5.4 specifically. So just wanted to throw that out on the record for future task force.
Thank you. You're absolutely right. I was in Austin last week at the ABA meeting and was approached by a fellow who's going to be the chair of the center, and they are very, very interested in California and what we're doing on the issue, and hope that they're going to be able to persuade the other states to follow suit. They really want a plan for taking these sorts of actions nationwide. Okay, further discussion about the 3 paragraphs. Bridget.
I do agree, I think we've said it before, that we should keep the sandbox in, at least as it's written. And my other concern is, I have a little trouble with the sentence, I guess it is the 3rd sentence, it says the members could only reach consensus regarding a modest revision. I think we talked about this last time, and I might have already gotten voted down on this one, so feel free to just ignore me. But to me, that kind of sounds like we opposed any other changes, and I just don't think that's really reflective of what our discussions were. I mean, to me, it almost, I mean, at least in my mind, that I realize that not everyone shares my view, but I feel like we are just basically holding off on significant revisions until we have the sandbox, at least with, but I know this is different than what Johan's just saying, but at least with respect to the non-lawyer ownership piece, we want to gather data before we recommend any significant changes. But to me, that's different. I don't know, the way it reads, it seems like it's saying we had these changes up and we all voted them down.
Yeah, I think our gut tells us that the changes have to be made, significant changes to 5.4. And the only reason we're kind of falling back on the data is to provide a level of comfort to the legal community that there's not going to be consumer harm. We're not going to be able to make that change until we're prove that, although I think we agree those changes are more than likely going to have to be made. So I don't know how you articulate that.
I don't know.
Well, yeah, I guess the question I would have is, do we need that sentence? You know,
No.
Our proposal is what it is.
Right.
It's limited. But we go on and say in this, that the members agree that additional revisions are warranted, but only after studying data that would support it.
Right, I agree. Yes, I agree with that.
That would be.
This is Lori. I'm not sure I agree with the idea that the task force as a whole believes that this needs to happen after. In fact, the whole point of this was to suggest that moving forward, any future task force looks at this not just in terms of the data pulled from the regulatory sandbox. So I think that sentence actually is important, and I think the paragraphs show that really as a task force, we can only agree on this one modest revision around the nonprofits, but I don't actually know that as a task force as a whole, if we took votes, I think it was clear that there were more changes needed. Some believe we need the data. I'm not sure all need the data. So in order to suggest future changes.
Lori,
that was my take on it.
I don't think we disagree on what we're saying about it, both of us, but I do think that the way that one sentence is about reaching consensus does suggest that there were a number of members who were against any change to 5.4. And I don't gather that that was really the case. And if we eliminate the sentence, it doesn't change the fact that we all agree additional revisions are warranted. And if people don't agree with that, they can vote against this.
Lori, you can't see a revision that's been,
She might, if she's on the Skype link, she can see it.
Are you on Skype so that you can see the revision that Mimi put on board?
I am on Skype, but of course it just blacked out as you started making those changes.
Well, Randy has suggested a revision that Mimi has put up on the board, which would say the members approved a revision to the rule that will allow expanded fee sharing without characterizing it as what sort of consensus could be reached. And maybe that's the answer. That looks like a pretty good proposal. Kevin?
I was going to suggest for the sentence after that sentence. I like that sentence, that change, but change it and take out the although. Instead say in addition, a substantial majority of the members, and I think that's true, agree that additional revisions, and instead of saying are warranted, may be warranted, but that further study and data informing the specifics of those revisions is needed.
Yeah. Okay, I'm gonna clean it up so you can see what it looks like without all the junk.
We're going backwards here. We're going exactly backwards. If you want to have a conversation about the sandbox, put it forward in the sandbox. That's fine. This is about 5.4. This isn't about, the two do not have to be linked. We're just further putting them together.
I just to address that, I would suggest changing they believe to
Put
say,
your mic on? Oh, yeah, just so that people can hear you on the phone.
Hi, can you hear me?
I would suggest changing they believe to of these, some believe, and you could make it more explicit, Mimi, that some believe that within a regulatory sandbox, others believe that such changes could be done separate and independently from such process. Something to that effect.
Heather?
I was going down the same way, that it sounded like an absolute that the solution would be to look to the sandbox, but I believe that there are ways outside the sandbox that this can be explored as well. So I think your comments go to that.
An extra sandbox.
Yeah, there's room to play outside the sandbox. So I think that you got to where I was going.
You're the marketing person.
There you go.
Joanna and Bridget?
Yeah.
You okay with that?
Yeah.
Yes, exactly.
Can anyone see if they can get the video to come back up? It's blacked out. It was good until about 5 minutes ago.
Can we also read it out loud?
LA, can you guys see what's on my screen?
Yes.
Okay, Laura, you should probably try leaving the meeting and rejoining, because LA has no problem seeing it, so it's not on my side. And we'll wait for you to rejoin.
Okay.
The video portion.
It's not flowing.
I know.
Exactly what we tinkered with. Thank you.
So there's something here that needs to be fixed, I think.
In addition, a substantial.
Yeah, you have.
Oh.
Is needed. So, I mean, you can oversimplify. Some members believe that a regulatory sandbox will provide informative data, while others believe that changes
Will provide, let me delete all the other stuff?
Yeah, I mean, just
Provide
make it super simple
informative data.
and then jump to your. Others believe that, make it explicit further changes to Rule 5.4.
Changes.
Maybe studied or maybe developed.
Could develop changes.
I guess studied. And, I don't know if this is too explicit, but without awaiting data from the sandbox.
Say regardless of the sandbox.
Or regardless of the sandbox. Because who knows if the sandbox ever actually comes to fruition.
But does everybody agree that it has to be studied and we have to accrue some data? So I think that clarification has to be.
I think that's true.
So, Johan, can you see the language on the board?
I can, yes.
Are you okay with this?
Yeah, I'm fine. Again, all I'm trying to do is get to move forward. I'm not trying to be granular here.
I hear you. Lori, are you able to see it?
Yes, I can see it, I'm good.
Okay. Further discussion? Is there a motion to approve the language as revised by the group?
Let me just ask this real quick. Is there any task force member that's on the phone that is not dialed into Skype that needs me to read the language that we're voting on?
I'm sorry, I couldn't hear a word of that.
Is there any task force member on the phone who is not on the Skype video conference that needs me to read the language we've revised?
Okay, no, I'm fine, thank you.
I'm fine, I'm on.
I'm good, thanks.
As well, yeah, Alan.
Terrific. Okay, is there a motion? So moved. Okay, Heather moved and Daniel seconded. Any further discussion? Mimi?
Okay, so the motion is to approve the clarifying statement as revised.
Correct.
Okay, Andrew Rita?
Yes.
Simon Bomey?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang?
Yes.
Abhijit Sivan?
Yes.
Jean Clausen? Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morse?
Yes.
Joyce Raby?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Dan Rudens?
Yes.
Mark Tuck?
Abstain.
Angelina Valverde? Joshua Walker?
Yes.
Thank you.
All right, so the language that we just approved is going to be plugged into the report on B1, the 5.4 that we already voted on. And
then I will entertain a separate vote or separate motion to authorize Kevin and leadership to work with staff to finalize the report on 5.4, including this new language. Is there such a motion?
So moved.
Okay, it's been moved by Joanna and seconded by Daniel. Discussion. Mimi, we're ready for you whenever you're ready.
All right, motion to authorize Kevin and leadership to finalize report, adding this new revised language.
God bless you.
Andrew Arruda,
Yes.
Simon Bomey,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang,
Yes.
Abhijit Shavan,
Yes.
Jean Clausen, Johan Gilshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Ruby,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuck,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
Terrific. Okay, we're moving to item B5. This is ABA Model Rule 5.7, and I have in my notes that we're going to hear from Mark and Kevin.
You want me to read them? So, this was discussed apparently at the February 4th meeting, and an issue came up concerning whether or not there should be an express exception to the proposed rule where the services, the non-legal services are performed by a lawyer acting as a fiduciary or trustee or other type of fiduciary. So I did some homework and put together a memo that tried to outline how the Supreme Court has looked at this issue in the past and how it's been looked at through other bar associations. And that's in this memo of dated February 18th. Let me begin by saying that I went back and looked at Professor Henderson's initial report that kind of kicked off this task force, and he spends quite a bit of time on these alternative legal service programs and functions that are existent and are quite prevalent in California and elsewhere, and mentions that 5.7 could be one of a series of rules that could be looked at. So, getting to the issue at hand, Kevin and Andrew Arruda put together a memo at the beginning, a very lengthy memo describing categories of legal services that could be recognized by case law as falling within 5.7, and those that would fall outside of 5.7. And so my approach was to look first of all at the case law in terms of those type of services that have been viewed by case law as not being distinct from the rendition of legal services that 5.4 would not apply. And that's the first part of the memo, and there's cases cited there that deal with dual professions and performing legal and non-legal services to a single client or a single matter that are indistinguishable or incapable of being differentiated, so that there is no legitimate way that one could say that all the rules of professional conduct would not apply. And I think that is consistent with case law, and I think our rule doesn't alter that type of situation. It's really the second category of cases that I think brings the question to the forefront. And in my personal view, there's a difference between conduct rendered by a lawyer in rendering non-legal services that would be covered by the rules versus conduct by a lawyer that would subject the lawyer to discipline. And I think that second category of cases spells that out, and they deal mainly, at least my research indicates, with lawyers performing fiduciary duties as either a trustee or in some other capacity. And those cases have been summarized to some extent, there may be others, but I didn't include them all, but you'll see that the language that troubles us, the Supreme Court has said over and over, that where an attorney who breaches fiduciary duty would justify discipline if there was attorney-client relationship may be proper grounds for discipline of a lawyer, and that's true. And 5.7 really doesn't change that either. So the bottom line is that lawyers, if you had 5.7 and you had lawyers working with non-lawyers and providing non-legal services, the lawyer is going to be held to a higher standard, no matter what the services are. And if the lawyer is acting as a fiduciary, well then, case law says that the lawyer may be subject to discipline for misconduct on his part. 5.7 doesn't change that. It does deserve a comment, however, because there's a great deal of confusion in this area, I think. And so when we get to it, I have proposed some comments that deal with this issue. But any kind of wrongful conduct by a lawyer, even if a lawyer was in business with a non-lawyer, as a bakery, it didn't matter. If you engaged in conduct that is subject to moral turpitude standards or a violation of Rule 8.4, you're going to be subject to discipline no matter what you do. And 5.4 then changes that. And so the recent case that Randy brought to our attention, the matter of Lingwood, my reading of that case is quite similar to a Supreme Court case called Snyder. They're factually similar in many respects. Lawyers who prepare trust instruments for clients and then make themselves the trustee of the estate and build in powers that gives them the right to borrow money and do what they want with the trust assets are going to implicate disciplinary consequences regardless of whether they're in the business of being a trustee or they just happen to do that for testators as clients, and later on they are breaching duties to the beneficiaries. They're going to be subject to a higher standard, and depending upon their conduct, they could be subject to discipline. The same thing's true with respect to business transactions. A number of the cases that are in this neck of the woods deal with lawyers who've done work for a client, and then while they may no longer be a client, but there's still that aura of trust and confidence that prevails and continues, and the lawyer convinces this former client to allow the lawyer to engage in business affairs with that client or to have an adverse pecuniary interest in the client's property. That's going to trigger one of our rules. So it's not true that none of the rules would apply to law-related services or non-legal services. It's just that the lawyer could still be subject to discipline depending upon the nature of his conduct. I don't think Rule 5.7 changes that, and I think a comment to make that clear would be useful. And then lastly, there are cases that talk about the fact that there are other consequences to the lawyer or to a law firm by entering into arrangements with non-lawyers in rendering non-lawyer services. Conflicts of interest, duties of confidentiality, fee sharing, all kinds of things can come up. If you don't meet the parameters of 5.7, you can run afoul of these rules. That's true too. And comment to that effect would be useful. I don't know exactly where we are with this rule. I think Kevin and I put together a memo that outlined what the rule should say, and that we listed a series of issues that should be taken up by the next implementation committee. In response to the concerns of this task force, I did go ahead and draft a series of comments. We can talk about those if you like, but comments 1 through 6 is intended to pick up each of the points that I just made and to provide guidance. Assuming that there was a rule, there could be other comments added to this. Let me just end by saying that our charter, I think, asks us to consider this type of arrangement as one of the menu of choices to narrow the justice gap and to provide better ways of delivering services to consumers, and because it is such a prevalent practice today in so many different forms, some of which are legitimate, some of which are not. I think it is a responsible thing to do for us to make a recommendation that this be looked at in terms of a Rule 5.7. Those are my comments.
Joanne?
You've already drafted comments to the rule to kind of California-ize it. Is there some reason why we're not just sending it to the board as you've drafted, asking them to send it out for public comment so it can be, cleaned up at that point? Because I just, sending something just to be studied, I think, is not as proactive as we would like to be. So if you don't have a problem with that, I think we should just send it to the board for public comment like we're doing with 5.4.
Mark and Kevin, you want to speak to that?
I don't have a problem with that. I understand Kevin's concern is a legitimate one, that you can't draft rule of professional conduct on the fly. And we have spent more time on some rules than we have on others. And so that is a reservation that I think everybody in the room would have. Having said that, I do think this is within our charter. And I think that we, having spent the time we have, we ought to pass on our work so that the trustees can consider it. And I do think COPRAC or some other committee could work on this if they choose to, or I'm perfectly comfortable with coming up with a proposed rule with comments and putting it up for public comment, whatever the will of this task force is.
Yeah.
Yeah. My preference would be here. I think the rule is pretty far along, but it hasn't really been vetted to the point where I would feel comfortable having it going on for public comment. Because there are a number, as I went through it again, just this morning coming up on the plane, there were a number of other things, issues that cropped up, particularly not in the black letter of the rule. The black letter I would be fine with going on for public comment, but I think you need to have the comments. You need the explanatory comments with it. And I think they need to be worked up a little bit better before they go out. My preference would be to see it go to COPRAC first and have COPRAC take a shot at it to build up the commentary that's attached to it, rather than send it out as it has been drafted. I raised it. There were a few issues that I raised looking at these.
Let me make a friendly amendment to that, Kevin, if I can. And I do think we should discuss and perhaps even vote on the issue that you discussed at the last meeting, and Randy has drafted as an alternative, an actual exception to this rule, to exclude who are serving in a fiduciary capacity as trustee. I think we should discuss that conceptually and maybe even vote on it. My concern about sending this back to COPRAC is that COPRAC has already come out with a draft opinion on this topic, which is rather controversial. So they've taken a position which is different than the position that's in this memo. And OCTC has responded to that in a very strong and negative way. And OTC's comments have some validity to them. So I would not recommend we go back to COPRAC. I think the recommendation should be that the Board of Trustees should appoint an implementation committee, which would include a representative of the trial counsel's office and perhaps other interested parties to study this, work through this dilemma. And now that I've said that, I think I hate to say this, there's two issues we should vote on. One is the fiduciary duty exception that some have discussed. And number two, as you see in my conclusion here, there is this fundamental difference of opinion, I suppose, that OCTC has raised in their very lengthy opposition to the ethics opinion, and that is that really lawyers can't disavow an attorney-client relationship. You just can't go out and tell the public these are services and there's no attorney-client relationship and the privilege doesn't apply, they take issue with that. And my response is, yeah, there has to be a legitimate basis for making, you can't just, like the Gordon case. The Gordon case is one of the worst cases of all. That's the lawyer who had these loan modification programs, and he had over the country, he had a bunch of non-lawyers working with him, and he kept saying, these are non-legal services, when in fact, they clearly were. So, OCTC is correct in concept, but I think it doesn't change the validity of this rule. I think there are situations, because the rule says the services have to be distinct. I don't care if you're in a separate business or you're in a law firm, if those services are not distinct and clarification is not made to the consumer that they understand perfectly that they're not getting the full panoply of protection of the attorney-client relationship, then no matter what you say, it's not going to make any difference. And the case law says that too. So I think we can cure this, but I think it should be a committee, a task force that has those stakeholders in it to work through these two issues and get it out for public comment. I would not send it back to the vote.
Please.
Because I just struggle to quite understand the connection between all of these rules. So 5.4, further revision to 5.4 has maybe kind of sort of been sent over to the sandbox or will be addressed by data or information garnered from the sandbox. What is the relationship between potential outcomes from the sandbox effort and the need for 5.7? Is there any?
That's hard to predict. My personal view is you don't need a sandbox for 5.7 because it has a predicate, it has a history, it's been adopted by a number of jurisdictions, it's been around for a very long time, and it involves an activity of lawyers and non-lawyers that's going on in California right this minute. And so I don't think the sandbox is essential for 5.7. 5.4, however that evolves, I think deals more with the rendition of legal services itself and does not deal with the alternative, which is innovation through technology, working with non-lawyers and lawyers to provide some non-legal service that helps narrow the judgment gap. Not to the exclusion of 5.4. Maybe someday, I suppose, if we got rid of 5.4 altogether and you allowed lawyers and non-lawyers to render services without regard to any distinction, I suppose you might be able to preempt 5.7, but I'm not sure we're in a position to make that judgment.
That's what I was wondering. So if you didn't have a 5.4, you would not necessarily need a 5.7.
I don't know.
Okay.
I don't know. I mean, I have no idea. I guess I can't say no to that, but I don't know if I guess your question, if you got rid of 5.4 today, would you need 5.7? It all depends on what replaces 5.4. We hear there's going to be more regulation, so okay. I just can't answer your question. I don't know. I just don't know. I do know there's such a need to narrow the justice gap, which has been driving my whole decision making here, that I really think there's so much we can do right now, and I would hate to wait. That's my concern.
Kevin and then Andrew.
Yeah, I just wanted to add one thing about 5.4, getting rid of 5.4. 5.4 regulates lawyers. It won't make unauthorized practice of law go away. That's going to be controlled, governed by statute. So you're still going to have the statutes. If you say 5.4, no longer restrictions on lawyers, but lawyers are still going to run into a problem with Rule 5.5, where they can't assist someone engage in the unauthorized practice of law. So you're going to have to do something more than just 5.4. Just to say 5.4 is the white whale, and that once you get rid of that white whale, you can sail the seas pretty much comfortably. That's a horrible analogy. Anyway,
I was going to say that.
Anyway, It's just not going to work. So, we've been using 5.4 shorthand, I think, really to enable folks to, non-lawyers to cooperate with lawyers to a certain extent, engage in, join with lawyers in providing legal services, make the provision of legal services more efficient. Some of that can be done without just getting rid of 5.4, making modifications to 5.4. And I think it is going to take a substantial amount of study before you're going to have a legal profession that's going to be comfortable with it.
People keep asking for examples of this, and I put in my memo, one of the obvious ones is the mediator. We're all mediators, but you don't have to be a lawyer to be a mediator. And in fact, there's many non-lawyer mediators, and particularly family law. And I have clients of mine that I've worked with for years who are in workplace investigations. You don't have to be a lawyer to be a workplace investigator, but you can have a firm made up of lawyers and non-lawyers doing workplace investigations today, right this minute, and mediation services and conciliation services. And I had an occasion, I went across Atrium recently, which is the firm that has started up to do, all kinds of consulting for startup companies. Now, these are highly sophisticated clients. They're not the people we're talking about, people law. But it's two firms. It's a two-firm solution. They got the legal services over here. You've got the non-legal startup stuff over here. And it seems to be working. It's going on now for 3 or 4 years. I haven't heard any complaints yet. But that's a 5.7 paradigm. That's what that is. That's a 5.7 model. Now, what has to be done to get consumers and lawyers and the public and non-lawyers comfortable with where the lines are drawn? That's what this discussion is all about. Because the lines are all over the place. And if you put some definite boundaries and some pillars involved, you might get some innovation, some technology going, some things that are really kind of innovative and interesting.
Andrew.
I'm good.
Oh, you're good?
Yeah, I don't need it.
Okay. Further discussion, Joanne.
I just really hate the idea of us having another committee created to study this and flush it out before it goes. We're talking, this will be another year before it does another working group to flush it out, go back to the Board of Trustees, given how infrequent the meetings are of the board. It just seems to me we could flush it out through public comment. When it goes back to the board, if substantive changes are warranted, it can go back to public comment then, but at least we're starting the ball rolling as opposed to assigning it to another group to finish. I'm comfortable sending it as it's been drafted to the board to send out for public comment. We have a problem, and if we just keep pushing it off to the next group, it's just going to take so long to get anything done. I would prefer we can make it an alternative. We can either recommend it go out for public comment, or they create a group to study it further, but I prefer it just moving forward at this point.
Okay. Do we have a motion?
I would second any motion you make.
Before we make any decision whether to go out to public comments, I think Mark has raised 2 issues that need to be addressed to identify what might go out for public comment. And I think we should probably address that in paragraph D.
Okay, Mark, you want to speak to that? The first you identified was the fiduciary duty exception.
I hope I'm on the same page as you. We're talking about the alternative that Randy drafted?
Correct.
Paragraph D, if you look at page 11 of the line.
Okay.
The attachment.
Yes, okay, so staff put together a draft, this is on page 11, of a subsection D, which would accept from the rule, when words are acting as trustees regardless of whether any beneficial trust is a client of the attorney. So I think Kevin's correct, we should discuss and vote on that.
Okay, and
My
now
motion
you can
is
discuss.
my motion would be not to include section D, that should be a comment, and not in the rule.
Could we make it a little more positive and let me make the motion to approve?
Oh, go ahead.
I don't know if anyone will second it, but I make a motion to include paragraph D.
Okay, it's been moved and seconded to include paragraph D. Does it, Kevin, does that go along with the comment? You would include Randy's comment as well?
That is correct.
Okay, so the motion is to approve subparagraph D and the comment on page 11 of the materials. And it's been moved and seconded. Discussion. Randy.
So the point of paragraph D was to deal with the main bone of contention that came out of the development of the COBRAC opinion and the Chief Trial Counsel comment in terms of if you have a rule like 5.7, and it's kind of different from the ABA because the ABA's rule just says you can go through the hoops and you won't be bound by the rules. Our version of 5.7 would say you can go through the hoops and you won't be bound by the rules or the State Bar Act. And the State Bar Act is where certain important duties reside. That's where moral turpitude, 6106, that's where duty to abide by the law, 606AA. There's a lot of things in the State Bar Act. The specific things that were being described as apply to a lawyer almost regardless of what they're doing. If they engage in moral turpitude in their life as Joe or Jane citizen, they are subject to discipline. But when you build into our version of 5.7, something that says you are free from both the rules and the State Bar Act, then that sounds like you're getting immunity from 6106, 606AA, and everything that's there. And so the suggestion to paragraph D was to recognize what a sweeping effect the rule would have, to say, at least as to the clearest thing in Supreme Court precedent, which is if a lawyer is acting as a trustee as defined in the probate code, they can escape the rules of professional conduct because vis-a-vis the public, they can't see the difference between a lawyer who has attorney fiduciary duties and a trustee who has fiduciary duties under the probate code. They're the same. And the cases will say, well, yes, you're governed by certain things in the probate code against self-dealing, but because you're a lawyer trustee, not just a non-lawyer trustee, you also have to comply with, for example, the Rule 1.5.1 regarding self-dealing transactions, that is on top of what is required. And so that was really the intent behind adding a D. It wasn't because I think I wordsmithed it and it's ready to go. I'm kind of reluctant to put it out for public comment as is. It was really just to tee up the discussion of that major issue. Because this rule would address both the rules and the State Bar Act, you need something to bring back in the disciplinary common law that I think is pretty well settled in California. And this one, as drafted to me, in some sense is under-inclusive because it says lawyer acting as a trustee when you could have a lawyer acting as a real estate broker who isn't necessarily a trustee but has some escrow duties that the case law has also said is covered because it's a fiduciary relationship. And so the earlier version of this was if you're in any sort of fiduciary relationship, it ought to be outside of this rule. But that was so broad, hard to define, that it was something that if you wanted to pursue it, you might have to circumscribe it a little bit, and that's where the trustee approach came in. Again, it wasn't being drafted to put it out for public comment. I don't know if it's really ready for prime time, but it is, I think, a major issue, at least some consensus on the substance of what should be done in a rule like this. Again, particularly one that says both rules and State Bar Act.
Kevin and then Mark.
Okay, just to add what Randy was just talking about, two separate rules revision commissions addressed this issue and declined to draft a rule because it was such a difficult issue to encompass the California case law. That was explained in Andrew's and my memo back in February of 2019, a year ago. There was just a difficulty in doing that. People stepped back from it. On the other hand, Professor the name of the professor again from Berkeley, who sent us the letter?
Bundy.
Professor Bundy takes the position that the Supreme Court has the ability, if it were to approve a rule, to essentially effectively overrule the common law duties as expressed in the case law. I don't think that's something that necessarily would happen. That's a position that he has taken. But trying to capture this, and I agree, and I raised that issue with Randy when I saw this provision, that it is a bit narrow. But I'm not sure that just putting in a comment would be sufficient to alert people to the fact of these other obligations that exist.
Mark.
First, this issue is not at all new. And if you look at the ABA model rule comments, it covers this very same issue that we're trying to do here. As I say in my memo, the rule does not suggest and never has suggested that a lawyer is not subject to discipline for engaging in conduct that involves moral turpitude or a violation of such rules as Rule 8.4. The model rules have made that clear ever since this rule has been in existence in the 1990s. So it doesn't, you don't have to change the law at all. You just have to clarify that all of the rules don't apply to non-legal services. That's the point of 5.7. But if you don't have a distinction between the legal and non-legal services, all the services will be subject to the rules. That's what the law is. 5.7 says you can have non-legal services that are not subject to all of the rules of the State Bar Act with respect to the provision of those services. That's what 5.7 says. It does not say that lawyers are not held to a higher standard and can be disciplined for conduct that violates the State Bar Act. And the question is, do you have to have that in a rule or can you put in a comment? Most jurisdictions put in a comment. And Randy suggested really is under-inclusive. It's not limited to trustees at all. And so that's the issue, whether or not you have to have an exception, which frankly is going to make the rule very unusual and perhaps more restrictive than it needs to be. Lawyers just have to understand no matter what you do, whether you're acting in a attorney-client relationship or not, you're going to be held to a certain standard that can subject you to discipline. And that's true under 5.7. That's what's at issue here. Whether you're a fiduciary, you're an escrow holder, you're a real estate broker, you're making cookies, it doesn't matter. You know, you're going to be subject to but you're not subject to all the rules. That's where OCTC is kind of off base. Is that all the rules are going to apply? That doesn't make sense either. So it's a question of whether or not the comments make it clear, or whether or not you need an exception to the rule. I think the comments are quite adequate to explain to lawyers, as we do with most rules, that the rule does not exempt you from conduct that is otherwise disciplinary under the State Bar Act. So I don't think there's a problem there.
Okay, so I believe we have a motion and a second to include Randy's language in D and the comments. Further discussion? Joanne?
For those who care, I agree with Mark.
I'm sorry?
I agree with you, we don't need it.
Okay. So you would vote no? Okay. Are we ready to vote? All right. You know the motion?
Yeah, the motion is to include paragraph D and related comment as drafted by staff. Okay. Andrew Rita?
Abstain.
Sam Bomi?
No.
Sarah Bird?
No.
Judge Wendy Chang?
No.
Abhijit Sivan?
Abstain.
Jean Clausen? Johan Trollshagen?
One sec. Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
No.
Andrew Kuchera,
Yes.
Joanna Mendoza,
No.
Kevin Moore,
Yes.
Heather Morse,
No.
Joyce Raby,
Abstain.
Toby Rothschild,
Yes.
Alan Rodriguez,
Abstain?
Dan Rumens,
Abstain.
Mark Tuft,
No.
Angelina Valverde, Joshua Walker.
Abstain.
Thank you.
That's the vote.
Motion fails. 3, 4.
Okay, motion fails.
Right?
Bridget?
Wait, hold on 1 second, I need to count. 4, 5, 6. So 5, 6, and so yeah, the motion fails.
Okay, Bridget?
I was just wondering if there's a middle ground between another committee and just sending it out for public comment. I mean, is there, because I agree with Joanna, I just would hate for this to be another like year-long discussion process, but it seems very complex, and I don't think that, I'm not comfortable just sending this out right now, if, given you guys that are the experts and the people that even wrote it being concerned about it going out for public comment. But that being said, I mean, is it something that you think you could resolve before we recommend this for the report? Or could we do like a mini task force, or could we recommend a short deadline or something that could be a middle ground here?
Randy, you want to speak to that?
Andrew actually has another idea for consensus building that might advance the actual rule draft to the point where maybe we don't need another committee. Maybe it is something that could appropriately elicit the right type of public comment, because the D language, again, that was just meant to focus the issue so we could talk about it, would have got public comment to kill the rule anyway. But maybe Andrew's version is better, because we are writing it now to try to get it out for comment.
Nobody get your hopes up, but one possible approach would be building off the language that Randy drafted, so paragraph D on the board. Notwithstanding paragraph A, a lawyer remains subject to discipline under Rule 8.4 of the Rules of Professional Conduct. And then it's one of two options, and the State Bar Act, if that's too broad, and 6106 of the State Bar Act, if you'd like it more narrow. Period and provision. So regardless of how they're acting, trustee, real estate broker, what have you, if you undertake disclosures to participate under Rule 5.7, the lawyer, or you are baking cookies, the lawyer might be disciplined under 8.4, the general misconduct rule, which you cannot disclaim anyway if you look at the language of that rule, as well as 6106, which would be my narrow version, or if 6106 was too narrow as being the only provision being identified in the State Bar Act, you could just say the State Bar Act generally, and that my idea is that hopefully captures the responsibilities a lawyer would have to abide by, regardless of, and then that alleviates all the other rules if you are properly contracting with a client under 5.7, and then we would also add Mark's comments but remove Randy's comment that's on the screen right now.
Mark.
I have a response and then a proposal. That's under inclusive because the cases I've reported in my memo talk about situations where you might have a business transaction rule application that you can't excuse even if 5.7 applies. So I think it's still under inclusive. Here's my proposal. If you're still hung up on this and you don't think a comment does the trick, then one thing that's very common to do is to put out a proposed rule with two alternatives, Alt 1 and Alt 2. Alt 1 is Randy's proposal.
We've been there before, you know.
And then let the unwashed masses decide, can we handle this in a comment, or do we have to have this in a rule, and what should the rule say? That moves the ball down the field. You don't have to worry about committees, and you can get some feedback.
And alt 1 would be without D or Randy's comment,
That would be my preference.
and the other alternative would be using this language and putting it, yeah.
I just have a couple of questions. One is, it comes back to the board. I know in the past, when the Rural Revision Commission sent something out for comment, it came back to the commission to review the comments. I don't see the board going into detailed drafting, dealing with the comments. So there's going to be somebody that goes to. And I think we need to think about how that gets defined.
Mark?
You're going to have the board putting together implementation committees, and I just don't think it should go back to COPRAC. They have already squared off with CTC with respect to this issue. I think the board can easily appoint a mini commission or study group to implement the comments.
Joanna, you agree with that?
Yeah, I mean, we leave that up to the board. We don't have to tell them what they should do after it comes back for public comment. They'll figure it out. I think, we're okay. It'll get worked out one way or the other. But I do like the two alternative versions. It does move things forward. Did you have a comment in the alternative you're talking about? You're incorporating the comments you already drafted, right?
On page
Yeah,
8
it's
and 9
in
in
the,
the memo.
if you look on page
8, 9?
Yeah, there's a 6 comments.
Page 8 and 9 of the memo, I have 6 comments.
And that would be alternative 1?
That'd be alternative
Okay. And then alternative 2 would be Randy's original with the highlighted section in the comment? Or would it be as revised?
Randy, you would agree with, you would leave in the other comments as well, in addition to the one that you've added, or?
Yeah, but I don't like the D that is restricted to trustees. It's just too narrow.
So you want to do this version?
You want Andrew's version then?
I actually would like Andrew's version with State Bar Act in D, and then you take State Bar Act out of A, basically. So we're just talking about, are you bound by all of the rules or some of the rules? Let's leave the State Bar Act out of it.
And you still want your comment, or Andrew suggested taking
I would take Mark's comments.
Mark's comments instead. So the only issue is paragraph D and A.
If you wanted an alt 1 and alt 2 to sort of give you the range and get the kind of feedback, this alt 2 would be a very narrow approach baby step towards what the ADA has in 5.7, trying to acknowledge the complexity because you've got those 6 comments and the big issue in terms of dishonest or moral turpitude type activities. It is a little bit at odds with Mark's comments, because Mark's comments includes some of the other things that might still be in the rules that you're bound by. So it's not perfect, and we don't have multiple meetings to refine it. So this is just sort of pitching best we can at the moment.
Okay, so.
I would like to make a motion,
Joanne.
that I would like to move that the recommendation from Adels be that these go out, that the board adopt these for public comment for 60-day period. The alt 1 that we've discussed, Mark has drafted an alt 2 with section D and Mark's comments included.
Second.
Okay, it's been moved. Is there a second? Dan. Okay. It's been moved and seconded. Kevin.
Yeah,
There's some brackets, though, in the original Mark's black letter that have to be resolved.
yeah, I'm looking at this, and I'd like first clarification as to why you're removing in the State Bar Act, which is in the paragraph A, which is something that we consistently include, especially where paragraph A is referring to where the lawyer is providing services in circumstances that are not distinct, and in the other circumstances.
So in the new paragraph D that I modded from Andrews, he was going to single out maybe 6106, but I think that would be under-inclusive. So I went for the whole hog and said, let's exempt the State Bar Act out of this because there's more there than just 6106. That's sort of the substantive way I would parallel it to the ABA because they have a comment that exempts 8.4, but ours is more than 8.4, it's 8.4 plus the State Bar Act. So just to make it consistent, remove it from A and put it in the exemption paragraph D. And there's actually another reason that is really more sensitive to the fact that the State Bar Act is from a legislative stakeholder who also has the authority to regulate the legal profession as permitted by the Supreme Court. And we're saying put something out for public comment. We haven't really had any consultation with our legislative representative to speak to our legislative stakeholders and say, we're going to pass a rule that says lawyers don't have to follow the State Bar Act anymore. And I just don't think I would want to move that fast in that direction, putting something out for public comment without.
I don't think that responds to Kevin's point.
Why take
it out of A?
Yeah, my concern is that throughout the rules of professional conduct, we never say subject to these rules. We always say subject to these rules and the State Bar Act. We don't talk about subject to discipline under the State Bar Act or anything. We always say subject to these rules and the State Bar Act, period. And taking it out there is why all of a sudden, where you're in circumstances that are not distinct from the lawyers or the law firm's provision of legal service, I'm looking at sub 1, are you suddenly not subject to the State Bar Act? It just doesn't make a lot of sense. And then moving it to D doesn't really help, say remaining subject. I take out subject to discipline, or take out the subject to discipline under, because that's not a phrase that we've used in the rules before, for one thing.
I mean, the rules don't have to parrot that you're subject to the State Bar Act every time we have a rule on the books. It's assumed that you're subject to the State Bar Act. I mean,
okay.
But
that's
if every other
really
rule
the
says subject to these rules in the State Bar Act, and then suddenly you take out State Bar Act.
Randy, can you
Especially when you're
leave
coming
State
up.
Bar Act in A?
I can live with the State Bar Act.
Okay, so why don't we put State Bar Act back in? And then I hear Kevin saying he thinks it ought to be subject to Rule 8.4 in the State Bar Act and take out the words discipline. Are you okay with that as well?
That's fine too.
Let me throw in another thing. Should Rule 8.4.1 be there? No discrimination.
Well, if you do that, then maybe you add sex with client and a couple of other things as well.
That's why I'm concerned with just saying subject to
These rules.
Why not these rules? Then I don't know
what we're saying.
There is no 5.7.
A2, the written disclosure. I think this whole discussion sort of illustrates and begs the point that this is good another group to look at.
Very difficult.
Mark?
Well, I just want to remind everybody that the orientation rule is to tell lawyers when they are subject to the rules. And that you are subject to the rules unless the services are distinct or unless you comply with A2. So it's not trying to tell you when you're not subject to rules, when you are subject to rules unless you do these certain things. And even then, a lawyer is not immune from discipline depending upon the lawyer's conduct. Doesn't sound like a very complicated proposition to me. It's pretty straightforward. And that's how it's read in other states, so it's not like it's difficult.
And in your view, your 5.7 with its comments does that?
Yes.
So do you want to make a motion?
Kevin raises a valid point before you.
No, we still have a motion to recommend to the board that they circulate Alt 1 and Alt 2 for public comment. Joanna made that motion.
Which was after the Okay,
Just letting you know.
but we don't have an alt two at the moment, I don't think.
Ask her to withdraw her motion. You can ask her to withdraw her motion until after.
Let's just find out, do we have an alt two? I just, Randy, I don't know where you are.
Okay.
I don't think it's prudent to try to craft an alt two that could actually be adopted by the board and sent to the Supreme Court on the fly in this room with the time limits that we have.
Or even that could be adopted, not adopted by the board, but approved by the board for public comment. I don't think we should even do that at this stage.
I think adding to that, you heard the vote the last time, I think the fact that virtually all of the tech-related folks abstained indicates that this just isn't the right group to do this.
Yes.
We need a group of people who are more into the ethics lawyering side of things.
Okay, Joanna, it's your motion.
I'd like to clarify, when the board sets something out for public comment, there's always language in the motion that says, we are not saying we agree with this or not agreeing with this. We are just trying to get feedback so we can finalize something if it can even be finalized. So no position is taken by the board. So the board wouldn't be saying, oh yes, we like these. They would just be agreeing to send them out for public comment to refine them if it's possible. So I just want that to be understood when people, vote to recommend that the board send something out for public comment.
Well, I don't think we can vote at this point on alt two when we don't even know what it says. I guess the question is, do Kevin and Randy think you can work enough on this between now and the finalizing of this that you would feel comfortable coming up with an alt two with this general proposition? I think we all understand what we're trying to do, that you could come up with language and that we could vote on Joanna's motion now or not, because I don't know what we're voting on.
I have a suggestion, and I'm kind of folding my hand right now, but my suggestion is that if the task force wants to send this out for public comment, if they're insistent on sending out for public comment, don't have alt 1 or alt 2. Just do an alt 1. Here's my concern, that if we were to do an alt 2 with the paragraph D that is either viewed as over-inclusive or under-inclusive, and we're already addressing the concept of fiduciary duties and comments, I think it should be all done in comments under those circumstances, and let it be accepted, criticized, or not, by addressing the issues that Randy has done. I'm a little bit concerned that the comments aren't necessarily sufficient as drafted to capture all of the concepts we want. But I guess I'm asking that perhaps if you were to give, say, Randy, Andrew, Mark, and me authority to try to revise these comments to make them presentable to the board. So
You're talking
in
about
other words, the issue of fiduciary duties that might be owed in a non-legal services context, you could still owe fiduciary duties. They would be addressed in comments. In essence, you would be authorizing us to flesh out the comments somewhat to capture that concept.
I would accept that as a friendly amendment to the motion, that we eliminate the alternatives and give authority to staff, Kevin and Mark, to work on a final version to send with the report.
Okay, that's the motion. And Dan, is that accepted as a friendly amendment?
Certainly.
Okay.
Just one point of clarification, not causing problems or problems. On comment 6, the way it's drafted, you say addressing conflicts of interest rule 1.7 through 1.1. Is that intended to be 1.7?
No, it should be. The ABA has 1.11, that was an issue I wanted to raise, but this is something we can address
We'll do that.
these
Okay.
issues
I just,
subsequently.
Yeah, it's supposed to be 1.11. It's supposed to be perfect.
but we won't agree.
Is someone on the phone?
Yeah, can someone please restate the motion, please?
Sure.
This is Wendy.
Hi, Wendy. I think the motion is that we send, well, first of all, we give authority to Mark, Kevin, Randy, Andrew, anybody else who wants to pitch in to tweak the comments to the rule, but the proposal would be to send out for public, that we urge the Board of Trustees to send out for public comment what comes out of that working group, which is the proposed Rule 5.7 with comments, and not send an alternative.
Okay, thank you.
Thank you. Any further discussion?
I just wanted clarification there. We won't make any changes to the black letter.
Correct.
But there are the brackets right now, so I think that is open for the drafters to resolve.
Can I speak to that? I have to say, I do wish we had more time to study this rule, but I put in brackets two things. One, whether the rule should apply to a law firm in addition to the individual lawyer, and number two, whether the separate entity would be owned by the lawyer or controlled by the lawyer. And that's a big issue at the ABA level. And I don't mind this going out for public comment with those brackets because you can identify those issues and solicit comments. My personal view, for a lot of reasons, the rule should be limited to a lawyer, not the law firm. Number two, it should, because of the innovation and the need for more synergy and technology, I would not want the entity to be controlled by the lawyer. I don't think the ABA has always insisted that the non-legal service entity be controlled by the lawyer. I think we can get away from that now for a lot of reasons. So I would leave it as just simply owned and not have control. But that's my personal view. I don't mind it going out for a public comment, but that's why I put that in brackets, because those are two discussion points.
Joanna, do you want your motion to be that it say just lawyer, not law firm, and owned, not controlled, or do you want to send it out with the brackets, alternatives?
The brackets is fine. I mean, that's what I'm hoping the public comment period will be for, is to get feedback on that.
Okay. Anything else we need to resolve before we vote?
And so I would have recommended get rid of the language in the brackets, because if I were a member of the public looking at a rule that's suggesting law firm discipline, knowing that the bar is doing a sandbox proposal where you're actually looking at regulating entities other than lawyers, I would say, why are you doing this rule that tees up a major issue of law firm discipline when you don't even know the potential harms or benefits that come from regulating things other than individual lawyers? And so you have the controlled entity and the firm, not the individual, that would benefit from sandbox data. So if you want to separate this from that and justify taking it on a standalone basis, then I would say get rid of the firm, get rid of the control.
I will make that motion, because I'm not strongly in favor of either one of those.
I'll second that.
Okay, well,
So is
it's
it
still
friendly?
Joanna's motion.
Is it a friendly?
So Joanne, is that a friendly amendment, that we get rid of law firm and we get rid of control?
That side of the table has reached consensus on that issue. I'm good with that.
Okay.
They were put in there for discussion purposes only, so if we're going for public comment, Randy's right, I think we should make a decision. I favor his approach.
Okay.
Agree, Dan?
Totally.
You're okay with it too, Dan?
Absolutely.
Okay. Further discussion? Mark, as I recall, there was a separate issue that you thought we needed to deal with.
Well, that's
in addition to Randy's exception.
Yes, I raised, for discussion purposes, in my conclusion, I don't think it's much of an issue, but I did throw in here, just because OCTC raises this point, that, now where to go? I know I lost my memo. that if you look at my conclusion, I say similar to the task force's view of existing lawyer advertising rules. Well, that's the wrong one, excuse me. Where are they here? I just mentioned that in the conclusion that I think that the proposed rule is consistent with California law with one possible exception. That is that the trial counsel thinks that lawyers cannot disclaim the existence of any kind of relationship or that services are not legal services if that's not the case. And I don't think that's a barrier to this rule at all. I think that's just intuitively so. And that's the Gordon case. The Gordon case is a lawyer who's obviously giving legal services, but he said they're not. But that's just the kind of deception that brings in 8.4 and all kinds of things. So I don't see it as an issue. I put it in my memo because OCTC raised it as an issue. So they can, it's one of those things you go for public comment and hopefully
Yeah,
get some
public
feedback.
comment, hopefully that'll
Yeah.
sort itself out. So when you all tweak the comments and the rule, you're also going to tweak this, the report.
Oh, yes.
Because your conclusion is, let's study this further, and I think that's not Joanna's motion.
Correct.
Okay. Further discussion? Everybody ready for a vote? I am. Okay, Mimi.
No, so I'm just gonna restate the motion. I think we should just hold it all in. So the motion would be to authorize Kevin and leadership to revise the comments and finalize the report, and to recommend that the board circulate for public comment. Right? All right. Andrew Rita.
Yes.
Seven Bowman.
Yes.
Tara Bird.
Yes.
Judge Wendy Chang.
Yes.
Abhijit Shaban.
Yes.
Jean Clausen. Johan Trollhagen.
Yes.
Margie Estrada. Lori Gonzalez.
Yes.
Bridget Grammy.
Yes.
Andrew Kuchera.
Yes.
Joanna Mendoza.
Yes.
Kevin Moore.
Yes.
Heather Morris.
Yes.
Joyce Brady.
Yes.
Toby Rothschild.
Yes.
Alan Rodriguez.
Yes.
Dan Rubens.
Yes.
Mark Todd.
Yes.
Angelina Valverde. Joshua Walker.
Yes.
Thank you.
Terrific. Thank you all very, very much. Mimi, do you suppose there's lunch?
Yeah, it's there, that's fine.
Okay, how about we take a break, have lunch, and meet back in here promptly at 1 to go on. Thank you.
The document request, public records act request.
Okay, we're gonna go ahead and get started. We are now on agenda item B6 for the certified lawyer referral service item. And I've got down that Kevin and Randy are gonna do a presentation on that.
So if you recall, a couple of meetings ago, we were beginning the discussion of the lawyer advertising and solicitation rules. And at the time, the legal match case, Jackson versus Legal Match, had just been issued. And among the subtopics under lawyer advertising and solicitation was the concept of compensation for referrals, which is covered by 7.2 and also 5.4. And the only exception really for compensating someone for a referral when they're a non-lawyer, client referral from a non-lawyer or a non-lawyer entity, is really the situation where the non-lawyer entity is a certified lawyer referral service. And that was recently addressed in the Jackson versus Legal Match case that was summarized a couple of meetings ago by Kevin. in terms of the crux of that regulatory scheme is when an entity is engaged in what would be a referral activity. And the referral activity that was found in the legal match case was essentially an online matching service. And so that, to some extent, was viewed as a broadening interpretation of the scope of the lawyer referral service regulatory scheme. And that led to a recommendation that we consider whether or not the existing statutory and rule regulation of certified lawyer referral services are really balancing innovative lawyer referral with public protection. And so we came up with recommendation language that the board consider adoption of amendments to those regulations following study. Because it wasn't really necessarily directly related to the tech innovation core of our charter, but is related. It hasn't been on our radar from the beginning. I don't think it was really assigned to any subcommittee. So I don't think there is much we can do with it other than identify the fact that it is something we looked at as part of our consideration of both compensation for referrals under 5.4 and the lawyer advertising and solicitation rules, and encourage that study be done. And the report and recommendation, that similarly is very limited because we didn't really have much to say in terms of guidance to the group. We never really put up for discussion any of the minimum standards for a certified lawyer referral service, nor any of the statutory provisions. And so, unlike the advertising memo, which we provide a bulleted list of the specific rule revision topics that ought to be considered, this one would be a wide open recommendation to whoever the board assigns to take a look at. Do you have anything more?
Nothing more.
So the gist of this is, do you still agree with the short statement of the recommendation? We capture the wording of the study that we want for LRS activities. And I guess if we are going to do anything more to tweak this report, staff would like to authorize leadership to work with Professor Warren to help us bring this one home. I can't make a motion.
I will so move.
Second.
All right. The recommendation has been moved and seconded. Discussion. Toby.
Quick comment that, often we can look at what other states have done with these things to get ideas of things, but for the most part, California's certified referral services are broader than most other states. We do allow, online, unmoderated referrals. You don't have to have a human involved in it at all. Most states still require a human being to make the match. So I think there's a lot of ways that looking at other states isn't going to help us. So we really need to study it ourselves and figure out what could we do further than what we've recently done. Adding that was, last year or 2 years ago?
Mark.
In light of discussion we had this morning regarding items B1 and B2, it seems to me you ought to put a comment in this recommendation that is without regard to recommendations that we're going to make, I hope, to study 7.2. Because 7.2 deals with fee sharing with qualified lawyer referral services, and then it defines it as being a lawyer referral service that has been certified and sponsored by the state bar. Hopefully the implementation committee will take a hard look at that definition, because there are many portals out there like Legal Match that either cannot or do not wish to be certified by the state bar, and yet they are performing valuable functions And so unless we're gonna say that we accept the Court of Appeals definition of what is a referral, that everyone has to be certified, which I think would be an over-restriction on access to justice. You want to put in here that there is also a companion recommendation that's going to be made, that the advertising rules on where referrals be studied separately from this recommendation. This recommendation doesn't exclude that recommendation.
Randy, are you comfortable with that?
So it's almost like which one should be done first in a way. If you expand the existing scope of what is permitted in terms of compensation for referrals under 7.2 B to include referrals not made by certified lawyer referral service, then in a way you might solve what might be some of what is viewed as the overbreadth of the current regulatory scheme. If, on the other hand, if you get into the certified lawyer referral service regulatory scheme first, and you narrow that perhaps to exclude certain things that are in the public interest, that aren't substantial harm, risk of harm, then maybe you don't need a major revision to 7.2. So it is something where I don't know if you could do them separately. I think you'd have to take them together if that is the area of regulatory reform that you want to address. And we can capture that in the revised report recommendation.
Okay, Mark.
I don't think you have to reach that issue. I'm looking at that paragraph we talked about this morning in agenda item B1 that says, although you made a recommendation regarding this particular proposal, ATILS is also generally recommending ongoing study with respect to some additional recommendations, including 5.4. The same thing here. That's all you're doing. You're pointing out to the Board of Trustees that this is not the only recommendation we're making with respect to referral services. This recommendation comes out of legal match, the case, and why the definition of 6155 is really antiquated and should change. That's this recommendation. But we should say there are other recommendations being made, assuming you get there, and you don't pass that, then you don't have to worry about this. But if you do, you should say something about it. That's all.
Okay, well.
Yeah, adding in all those sentences is fine. I don't want to belie the interrelated nature of it and lead someone to believe that, like the 5.41, one is completely simple and can be done on its own.
Right. Okay, Joanna, it was your motion, right? You accept all of that as part of the tweaking process?
Yeah, I don't. I don't know that it really affects the motion whatsoever.
Okay.
So, I mean, that's fine, I'm sure. Again, it comes down to the final drafting.
Right.
And we're giving people authority to do that.
Yeah. From afar.
Yes, very far.
Okay, any further discussion about the recommendation or the motion? All right, Mimi?
We're taking two separate motions or one?
Two separate motions, all we're doing is approving this recommendation first.
Okay, so the motion is to approve the recommendation as stated, assuming that staff has some additional language. Andrew Arruda.
Yes.
Simon Boney.
Yes.
Tara Bird.
Yes.
Judge Wendy Chang.
Yes.
Abhijit Shabbat.
Yes.
Jean Clausen. Johan Drolshagen.
Yes.
Marty Estrada. Lori Gonzalez.
Yes.
Patrick Grammy.
Yes.
Andrew Becerra.
Yes.
Joanna Mendoza.
Yes.
Kevin Moore.
Yes.
Heather Morse.
Yes.
Joyce Raby.
Yes.
Toby Rothschild.
Yes.
Alan Rodriguez.
Yes.
Dan Rubens.
Yes.
Mark Tuck.
Yes.
Angelina Valverde. Natasha Walker.
Yes.
Thank you.
All right, and then the second half of this, as with some of these other proposals, I would entertain a motion to authorize Kevin, Mark, and leadership to work with staff to finalize the report.
Moved.
Second.
All right, it's been moved and seconded. Discussion. Minnie, whenever you're ready.
Ready. Andrew Rita?
Yes.
Simon Boney?
Yes.
Tara Byrne?
Yes.
Judge Wendy Chang?
Yes.
Abhijit Shaban?
Yes.
Jean Clausen? Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Graney?
Yes.
Pedro Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morris?
Yes.
Joyce Raby?
Yes.
Toby Rothschild?
Yes.
Ellen Rodriguez?
Yes.
Dan Rubens?
Yes.
Mark Tuff?
Yes.
Angelina Valverde? Joshua Walker?
Yes.
Thank you.
Okay, that's B6. We're moving on to B7, the advertising and solicitation rules, and I've got down Mark and Kevin.
So back in January, Kevin and I put out a memo on introducing the lawyer advertising, solicitation, and matching services issues, and it contains a pretty detailed discussion about the background for the changes to the ABA model rules in terms of improving access to justice. And it contains those materials. Then on February the 20th, we submitted a second memorandum, which contained a short statement of our recommendation and then includes a listing of specific changes to the current rules that the implementation committee ought to consider. And that goes on for several pages, but did not have any particular draft rule. So I wasn't here at the last meeting, but I understand that the suggestion was made to be more specific in terms of what are the actual recommendations that could be made. And so staff then prepared a set of draft amendments to Rule 7.1 to 7.5, which it sent to me and to Kevin. I made some comments to them, and they're in the materials, are they not? I think they are. And so the question for the House is whether or not specific draft amendments to the advertising rules should be included in the recommendation that goes to the Board of Trustees, or should we simply limit our suggestions on the advertising rules to only the list of issues that we identified on initially January 31st and again on February 20th. That's the issue before the House. My 2 cents is that hindsight being what it is, that the advertising rules which is all, it's part of our charter, and we're supposed to study these things and come up with recommendations. To me, this was low-hanging fruit. This was something that we could have easily gotten to and come up with specific recommendations, at least give the Board of Trustees some specific recommendations to make. Time being what it is, we're at the end of the term here, and as we discussed with 5.7, it may be difficult for us to come up with a consensus on all of these changes. So I have to say, I personally am disappointed, but realistically speaking, I could go either way. So I'll let Kevin pick it up from there.
Okay. I think if you spoke with staff and Mark, I was vehemently or adamantly opposed to attaching any proposed rules because they haven't been vetted at all. You might argue that the ABA rules were vetted, but I see there are some problems in the rules because in the ABA they folded the black letter of 2 rules into comments for the most part of other rules. And our approach here in California to comments are completely different from the ABA's approach to comments. And I just don't think it would be advisable to do that. I'm good with the memo as it is because it identifies specific provisions that might be added. I would recommend, though, that one bullet point be removed in its entirety from the memo. and that is on page 3 of the memo, the fourth bullet point, 7.382, really is irrelevant to our charter. It talks about experienced users of the type of legal services, and it's limited to business law. We're not talking about people down here. This is not something that should be part and parcel of our recommendation. We can add, maybe in a footnote, that although it's not part of our charter, any group that is studying amendments to the ADA should also consider this, but I don't think it should be put in the body of the memo as a recommendation that we are making. The other point that I had is the first bullet point on page 3. We already have a provision in the current California rule regarding a gratuity. And I think we just need to add a mention of that yes, we do have a provision that talks about it's okay to give a gratuity after the fact for someone having referred a matter to a lawyer. This is really focusing on the concept of nominal, what is a nominal gratuity. And I think that needs to be clarified a little bit so it's not confusing.
You agree with that, Mark?
I'm sorry?
You agree with that last point? Clarifying the issue of the nominal gratuity.
I'd have to know what the clarification would be.
Because we already have a provision in the current California rules regarding gratuities. It just doesn't use the word nominal.
I think that's an issue that ought to be considered by the implementation committee. I wouldn't take that.
No, I'm not saying take it out. I just want to clarify that we recognize that there already is a provision regarding gratuities. I was confused when I first saw that because I knew we had it. And the focus of this comment is on the nominal.
Which bullet point are you on?
The first bullet point on page 3.
Okay.
Because we have it in 7.2b5. We already have imported the language from old 1 through 20.
I don't mind clarifying it.
Okay. Further discussion? Does someone want to move the recommendation?
Actually, one.
Yeah.
So one point of further discussion. I actually think that on the previous one, I think it was bullet point 4. I think probably small business matters are a concern of access to justice. I mean, as a small business owner myself, I think that is kind of in our scope to some degree. I think it's toward the periphery. I think the main concern is the people law sector, but I think there is certainly a portion of what we need to think about as far as giving small business owners access as well.
Kevin.
It's not talking about access. This is talking about calling up someone in person or on the telephone or pounding on their door, why don't you hire me? That's all that this is talking about, and it specifies the ABA as experienced users of these types of legal services. Whereas if they're new business owners, sure, you can send them a letter and so forth, you can advertise you're available to do that. That isn't precluding it, it's just the concept, the cold calling concept, that it's permitted only if it's experienced users.
Okay, thank you.
Never
mind.
No,
You would say the same thing.
I'm sorry, I'm still confused. Are you proposing we take that out? I thought we had crossed it off a minute ago, that we're not limiting it to experienced users.
No, I'm saying take this recommendation out, take the bullet point out, drop it into a footnote, and explain that although it's not particularly relevant to our charter, we recommend that any group that studies revisions to the model rules also consider this provision in the ABA rule. That's the recommendation.
So would that, by putting in the footnote, are we suggesting that it should be limited to experienced users of that type of legal services?
Yeah, because it's a big deal that.
Because I would totally disagree that it should be limited to a quote-unquote experienced user. I think it is an access to justice issue, individuals are perfectly capable of responding to live, or online person-to-person interaction. I wouldn't want to limit it or suggest that we want to limit it.
Mark?
To focus this discussion more closely, the ABA revisions, which I'm encouraging our bar to study, has the two main protections. You can't overreach, you can't be deceptive, you can't be dishonest, and you can't be overly invasive or coercive, no matter who you're contacting. At the same time, what drove this compromise is what it is, because it does limit it to experienced users of legal services, takes into account the realization that face-to-face communications about the availability of lawyer services is extremely common. It happens on golf courses every day. It happens in cafeterias and coffee shops all over the place. And so the original rule that made this a prophylactic ban, that you could lose your license, if you had any such, face-to-face communication, was done in an era of protection where consumers did not interface with, information about legal services from lawyers as directly as they are now. Consumers are much more sophisticated. According to the survey that we did, as I was the chair of the April committee years ago, 78 to 84% of all complaints about solicitation come from other lawyers. They do not come from consumers. Consumers are not at all concerned about it. The public protection is when you're overreaching, you're overly intrusive, you are invading their privacy or what have you. That's already in the rule. But to have a ban, it'll be honored in the breach. If you keep this in the prophylactic ban, it'll be honored in the breach. But Kevin's point is, well, they're not experienced users because after all, they're not getting any legal services. So why are we talking about it? I would leave it in. I think it's something for the implementation committee to study, and we should not exclude it.
But I'm not arguing that it be excluded. I'm adding to drop it as a footnote in recognition that it is not specifically an access to justice issue when you're talking about the experienced users of legal services for business purposes. That's what the ABA rule says, and that's what the recommendation is saying. And I'm just saying it's not part of our charter.
Joanna?
I think we should leave it in. We're not taking a position, we're just suggesting we study with the rest of the rule, and I think it's appropriate. And on that, I would move that we adopt the recommendation as drafted.
Okay, the motion is to adopt the recommendation as drafted with that paragraph in. Is there a second?
Second.
Okay, it's moved and seconded. Discussion.
I mean, I want to study it, but I don't want it to say, I would just remove that.
It says whether. It doesn't take a position.
Yeah, but why does it have to narrow it down? Can't we leave it as should be broadened to permit live person-to-person solicitation, period? Does it have to include the quotation experienced users of the type of legal services involved for business matters? I just feel like that inherently narrows it, as opposed to just saying, we want you to evaluate broadening this, which I do want to evaluate broadening it. I don't want to evaluate broadening it and then to that narrow of a scope, if that makes sense.
I think that this is in reference to the fact that the ABA rule makes that distinction.
Right.
This is saying, do we want to look at the ABA rule and its limitation, or do we want to go broader than that?
Right. Well, that's still I would still remove that personally.
Yeah, I think, isn't it true, correct me if I'm wrong, Randy, but I thought Washington's new rule is broader in terms of face-to-face solicitation. It did not adopt.
Correct.
So I'm with you. I think we should study it on a broader.
Can you explain to me why the way it's drafted wouldn't allow for that anyway?
That's true.
I think it would allow for that, but I think inherently when someone reads this, they're going to say, oh, we should study the way the ABA did it, instead of let's just study permitting person-to-person. Maybe it's just a psychological difference, but that's how I perceive it, and I can see us just being like, well, the ABA's already studied it, so all right, let's go with that, as opposed to starting from a.
California has never, ever said, oh, well, the ABA's done it.
That's fine, but
I
I
have
still.
the point.
I recognize your point and I still disagree.
Probably, yeah.
I have no idea where we are. Joanne, this is your motion. You want it as drafted, leave that language in?
I do, and then, you know, if there's a strong feeling otherwise, we can propose it differently if it loses.
Okay. Further discussion?
I think the motion, it includes Kevin's clarification to the first bullet on page 3.
Correct, I put a note.
Okay.
Yes. Okay. Hearing no further discussion, Mimi.
All right, the motion is to approve recommendation as revised. Andrew Rita,
No.
Simon Bowman,
Abstain.
Tara Bird,
Yes.
Judge Wendy Chang. Wendy,
Oh, no.
Abhishek Shaban,
Abstain.
Gene Clausen, Johan Drolshagen,
No.
Margie Estrada, Lori Gonzalez. Lori, are you there? Okay, Bridget Graney,
Yes.
Andrew Kuchera,
No.
Joanna Mendoza.
Yes.
Kevin Moore,
No.
Heather Morris,
Yes.
Joyce Beatty,
Abstain.
Toby Rothschild,
Yes.
Alan Rodriguez,
No.
Dan Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you. No, the motion passes, carries.
863.
Yep.
Okay, the motion passed.
We gotta take another motion on authorizing someone to.
We do indeed. I would entertain a motion to authorize Mark and leadership to work with staff to finalize the report.
So moved.
It's been moved and seconded. Discussion. A lot of debate over this.
Sorry, who moved in second?
Joyce and then Dan. Andrew Rita,
Yes.
Simon Bowman,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang,
Yes.
Abhijit Shaban,
Yes.
Gene Clausen, Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez, Bridget Graney,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes.
Joyce Brady,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
That's a hard yes.
Mark Tuff. Mark?
Yes.
Okay. Angelina Valverde, Joshua Walker.
Yes.
Wow.
What do we do?
Exactly. Okay. Well done, folks. We need to talk just for a few minutes then about, well, we could actually talk for the rest of the afternoon. About the March 12th board meeting. Randy, you want to address that?
So we're still working through with board staff and leadership as to the presentation that's being considered for being taken up early, I believe, in the board's meeting on the 12th, that there would be board committees that would precede the full board meeting. And if they start with open session, at the last staff meeting, there was discussion of the ADLS group and recommendation either being the first or second action item in the open session. There might be a report from the Office of Access and Inclusion on the justice gap that might go before it, and maybe that's a good idea because it appropriately lays a good foundation for what would come next. And so we're thinking it would be early on in the board meeting on the 12th, and we know that Joanna is unavailable to assist. I think Joyce is also standing down. So is there anybody else, once staff starts talking about finalizing the presenters, we know we're going to be calling upon Justice Edmond and Toby, but is there anybody else who completely can't assist in the presentation on the 12th and will take you off the list? Okay, Andrew.
This is March 12th.
This is March 12th.
And where is the location?
It's going to be here in San Francisco.
Okay, yeah.
You're good?
I'm good to go, yeah.
Okay. Okay, and we know who we can call upon. We just haven't had a chance to figure out how we're going to combine the recommendations. We're definitely going to be relying on Toby to give us a legal services standpoint, and we'll probably be looking for someone who can talk about the rules in terms of the professional conduct revisions, and probably someone with the technology background, because so much of a focus of the tech-driven exception in the recommendation for the sandbox could raise questions from the board members. But we'll be in contact with all of you about the presentation that will be made.
Randy, can we talk for a few minutes about the logistics of all these reports? And we passed all these things talking about how individuals and the leadership will review everything. What do you see in terms of timing?
And so we have to get to work on it right after this meeting. Probably start with the ones that are furthest along and prepare them for review by the leadership and the designated point person.
And you'll send them out to us as they are
as they're being done.
Randy, what time is it?
Probably. They were wanting it as soon as possible, so we're just going to try to get it.
I would say like 1:30ish by the time the board starts.
You talked about deadlines with anybody?
I'm looking at Leah now because they were wanting it sooner than later, I believe. And the board's agenda goes up 10 days before March 12th. But I think even that would be an aggressive
That's next week.
timeline to make.
March 6th would be the normal posting date, which is,
Next Friday.
12 days or 13 days. I don't think it's realistic. So I think,
We'll just have to do it as efficiently as we can.
I'm confused. March 12th is the meeting.
And the posting date for the materials, not the agenda.
The agenda is 10 days.
The material, just the Friday before.
Yeah.
But that's an internal rule.
Got it.
And understandably, the members of the board would want it as soon as possible, given the gravity of the matter being presented. So we're just going to have to do our best.
You can always provide them with this draft in advance, letting them know a final is coming if they want to kind of have a better understanding and more time to review it beforehand. Just let them know. Things have to be done.
I mean, to that end, we do have the so-called short statements, and while there's quite the pyramid below that tiny tip top of it, to the extent that those have been approved, we can certainly share with them the short statements as recommendations.
Okay. Anything else for the good of the order? Yes.
Would it be possible to just get like an overview of how things all will play out with the rest of the task force? Because I think it would just help mentally be able to know what happens next.
We can. We can do a bit of a roadmap in terms of what is expected as the next step for each recommendation, and we can send it out after the meeting so that if you're asked, then everyone's on the exact same page, because there's a number of things that are going to be folded into what we're calling an ADLS Phase 2 that would have as one of its primary charges the development of an implementation of the sandbox proposal. And then there are rules that are being recommended that will go directly out for public comment and begin that processing path. And then there is one recommendation, the UPL exception, that we're saying when the board acts in March to appoint its paraprofessional working group, that we want all of our key principles that came out of that to go to them. So we can definitely prepare something that tells you where your good work is going, and we can send that out.
That makes sense, Andrew.
Yeah, it would be super helpful, just for more context. Typically, it's tough to answer questions from the public as to what's happening and where things are going, because the answers to those questions are throughout various emails at times, so just having it all in one place would be very helpful. And also, if you wanted to put it in a format that also allowed for the public, so a link can be shared when folks ask that question, it could be also very helpful, rather than just an internal email.
It could be an updated ADLS fact sheet.
Yeah, an updated ADLS fact sheet makes sense.
I would add to that, in addition to the textual simplicity, we could be thinking, given the misperceptions that we're navigating right throughout this, whether it's any of the sessions or the reactions we've gotten on the targets, et cetera, we can think about a communications strategy up front, again, to maximize transparency, but also the simplicity of what we're trying to do. I think it's worth thinking of that in advance, even of the board meeting.
We will be working directly with our communications, media relations staff person to make sure we're getting all of the messaging correct.
Anything further? Yes.
Is the University of Chicago, is that report going to be public? Is that something that, I just am curious when they finally finish the data analysis, if it's going to be posted somewhere, I'd love to get a heads up just to read more. I mean, I thought their conclusions were really interesting, and I think it would be an interesting document to have publicly available.
We could put it with ADLS page.
And we'll actually, the plan is to include it as an attachment to the agenda.
Okay.
Great.
Thank you. That was it. I'd like to see.
All right, well, let me just start with some thank yous. First of all, Neil, thank you for being here throughout this entire process.
No, I haven't. Just the last
Just
third.
seems like it. Someone from your office being here the entire time, so we thank you and we thank the chief for the willingness to participate. Thank you to the State Bar staff. You all have been amazing. And unfortunately, you're not done yet. There's going to be a lot to do in this next week. And then finally, let me just say thank you, and Leah particularly, thank you for sticking around. You could have abandoned all of us, and I can't tell you how much we appreciate that you did not. And finally, to all of you, I mean, obviously there has been so much time and effort and careful thought that has gone into all of this. You folks on the phone hearing this? They're gone. They're out of here.
No, Your Honor. Wait. I'm still here. I thank you also, Chairman Shining. I said yes.
It really has been.
Thank you all.
It really has been an honor working with all of you. And again, your work's not done yet either. There are a whole lot of people who have been authorized to continue working on this in order to get it into the hands of the Board of Trustees. And thank you in advance to those of you who agreed to accept and come to the Board of Trustees meeting. It has been delightful, and I thank you all very much, and have a safe trip home.
To thank our chair for
Yes.
working us through this.